make provisions for the use of technology by the registrar of political parties on the management of political party records. These honorable members will safeguard and enhance an electronic electoral system. And that is what Clause 32 provides for, Mr. Speaker. It proposes to amend the Election Act to mandate the registrar to certify nomination rules and membership lists of the parties, and you require, therefore, to go electronic. Mr. Speaker, I take this opportunity to welcome honorable members back from their festive season and further invite each senator to give their wisdom as we astutely and judiciously consider the amendments in this bill. Mr. Speaker, with these few remarks, I then beg to move and ask Senator Rengo to second. Thank you, Mr. Speaker.
Mr. Speaker, I thank the mover, the majority leader, and this bill is essentially very straightforward. We cannot pretend that over the years our governments have operated on the basis of cooperation between political parties. Even in earlier elections and formations of government, the Grand Coalition government, the NAG government, these were essentially coalitions. And I want to commend this bill because it does provide a framework for establishing coalitions and make it possible for those coalitions to operate in such a way that every party and every individual who is a member of a party which forms part of that coalition would know that their rights are enshrined and a legal framework to deal with the problems that may arise. And I know those who have been observers of the various coalitions we've had, that down the line they have had some problems, but there was no legal frameworks to do so. Secondly, under the entire umbrella of trying to bring the nation together through a political path and a political framework and institutions, with the reality of doing so through a recognized political framework and legal framework is ever so essential. Secondly, Mr. Speaker, the question of the political parties fund has been a matter that has been discussed within various coalitions. There have been attempts to try and bring legislation to enable parties who have not met the threshold previously to be able to benefit from the political parties fund. And I think this is positive. This is very positive. Thirdly, Mr. Speaker, in this bill, there's a definition of what a political party is required to do in terms of making its policies clearly. If you look at the regulations and the schedule of the Political Parties Act at the moment, each party is required to state clearly their objectives. But I think the fact that now they are required to state their ideology and world view and vision and the likes, we may be entering a new period when political parties can be known not by what they do only, but what they aspire to do, so that the political party system is strengthened within our country. Lastly, Mr. Speaker, I want to disabuse anyone, because I know there have been concerns expressed. This political parties bill has not in any way abrogated the Constitution in terms of political rights under Article 38 of the Constitution. They have not limited any rights under the Constitution, particularly the freedom of association and assembly. Those rights are intact, and the Constitution is very clear on the supremacy of the Constitution as against any statute or any regulation made under any statute. What is also intact, that the right of any individual, particularly as provided in the Bill of Rights, when threatened, not even when violated, you have a remedy through the Constitution, Article 22 and 23 of the Constitution. You can invoke the powers of the High Court. So anybody that was harboring any fears about the constitutionality of this bill, I think it'll meet the constitutional muster, and I know that anything that may be brought up against this bill is not for its provisions, but for the political objectives that one may probably have. But I understand this. There are those people, whenever a new idea comes, they are always opposed to it. Like when we were bringing a constitutional framework for increasing money going to the counties, some people are opposed to it. But now I can hear them saying, no, now we want it. There were ideas when this constitution was being brought into place. They say this constitution is bad. 20%, 30% of it was not good. They wake up 15 years later and they find out it is good. So for those who it take too long to sleep when people are awake, be damned. But for those who want to move ahead, this bill commends itself to be passed, and I ask the Senate to pass the bill. With those few remarks, Mr. Speaker, sir, I beg to second. Thank you.
Honorable Senators, I now propose the question that the Political Parties Amendment Bill, National Assembly Bill number 56 of 2021, be read a second time. Senator George Haneri.
Mr. Speaker, I want to thank you for giving me the opportunity.
Maybe sorry for interruption. Since I see a lot of interest, I was going to propose that for everybody to get a chance to talk, if we can use 5 minutes, that will give everybody an opportunity at least to talk. Thank you.
Yeah, Mr. Speaker, we'll try and comply to that. Let me take this opportunity to thank you for giving me the opportunity and state at the very onset that I support this bill, Mr. Speaker. Mr. Speaker, I support this bill not for anything else. I have read this bill, internalized it, and I think, Mr. Speaker, this is a very good piece of legislation. As a House, the House of Senate, we must always endeavor to enact, or rather pass laws that add value, that improve service delivery to the people of this country, that better their lives of Kenyans, and improve on governance. Mr. Speaker, having gone through this bill a number of times, I'm left wondering why there was so much hullabaloo in our neighboring house when they were debating this bill. I have a lot of confidence in this house. I know that we are going to have a very mature debate and agree on the way forward. Not that I'm casting aspersion on our neighbors, but Mr. Speaker, I sat in that chamber for 4 consecutive terms. Mr. Speaker, I never experienced what we saw in December when they were considering this bill. I never experienced that. The nearest that came to that was, I think, the late Honorable Otieno Kajwang and the late Mwenje fighting on the corridors, not in the chamber, in the corridors. Maybe the other incident I'll remember is Mheshimiwa Ojwang Kombudo removing his shoes and banging the dispatch box there. But I never, for the period I was there, I never experienced fist fights and people biting other people's noses and ears. So, Mr. Speaker, I want to say that this bill improves or betters the existing legislation, the existing act on political parties bill. For it has made so many new provisions that are very good for the country. Just to give one or two examples, in the current act, the role of political parties is not specified. The act just establishes political parties, but it does not go further to say what is the role of a political party. Mr. Speaker, this bill provides explicitly what is the role of a political party. Maybe just to go through the functions, the roles and functions of a political party have been provided for in this bill, and it includes to promote representation in parliament and county assemblies of women, persons with disabilities, youth, ethnic and minorities, and marginalized communities. It also provides that a party may sensitize the public on the functioning of the political and electoral system, among other roles that have been stated here very clearly. So it is absolutely important that when you are forming a political party, you know why you are forming a political party. For now, we just use them as vehicles for election. But this bill now gives proper roles and functions of a political party. Mr. Speaker, this bill also goes further to streamline the whole process of registering a political party, having in mind that this is an information technology era. When the previous act was passed, Mr. Speaker, we were in a different era where things like website were not in existence, but this bill now says that a political party shall include the address of the official website of the political party and file that with the registrar when they are registering. Mr. Speaker, this bill also gives clear guidelines on formation of coalitions. It gives clear guidelines on distribution of political parties' fund. And I think the threshold has been reduced. Earlier on, Mr. Speaker, you had to get 20 members of parliament, to be able to qualify to get a share of the political party's fund. But this has been reduced to one. If you have one member of parliament, you have one senator, this has been reduced from 3, one governor reduced from 3, and one MCA reduced from 40. Then you qualify to benefit from the political party's fund. Mr. Speaker, this is progressive. We must support this bill. I see my time is up. We must support this bill. I support it the way it is. I know there are friends and colleagues who are proposing amendments. We are ready to look at the amendments. If they make sense, Mr. Speaker, yes, we'll consider them. But as it is for me, I support the bill as it is, and I think it will go a long way in streamlining the management of political parties in this country. I support, Mr. Speaker. Thank you.
Senator Halaka Abshiro.
Mr. Speaker, I thank you very much. I rise to support this bill. Mr. Speaker, the Political Parties Amendment Bill, National Assembly Bill number 56, is a welcome and very timely piece of legislation. And like my colleagues have said, it is timely that we have this, and I will, given the little time there is, I'll limit myself to 3 things, Mr. Speaker. As you know, I'm the chairperson for the Center for Multi-Party Democracy, and as such, I'm going to go straight to the regulations of coalitions, reviewing of formula for sharing funds, and the strengthening of office of the Registrar of Political Parties. Mr. Speaker, looking at this bill and the part that pertains to regulations of coalitions, I am very impressed and note that the proposal to make provisions for the registration of political coalition and for issuance of full registration certificates to political parties that deposit coalition agreements with the registrar is a very welcome and timely piece of provision that the political parties have been lacking in this country for a very long time. Whereas there are many ways of ensuring that coalition contributes meaningfully to multi-party democracy, an effective regulatory framework would go a long way in improving the performance and utility of political parties, and therefore, currently, coalition arrangements have several shortcomings. We are very happy for instance, as political parties, with the specific legislation for coalition building, which is very timely, progressive intervention in this bill. This is needed to regulate the formation and management of coalition governments, to protect individual party ideologies and platforms, and to ensure that voters are still able to make choices amongst the competing parties and formations to stabilize coalition governments and to strengthen parties, Mr. Speaker. Mr. Speaker, with regards to funding of political parties, I strongly and very much welcome the proposal to redistribute political parties' funds as provided for in the bill, addressing both individual parties and coalition arrangements, Mr. Speaker. Again, as the chairperson,
let's consult
the
in
Center for
terms.
Multi-Party Democracy, a democratic system is best served when established parties last longer than an electoral cycle. Mr. Speaker, we've seen most of our political parties exist just as a political vehicle for elections. And this bill is going to ensure that the sustainability in our political party systems beyond an election cycle. The proposed new criteria for distributing the fund is fairer and will promote inclusivity and address the feuding in political parties and coalition arrangements, such as what we've witnessed in the last few cycles of our elections. Mr. Speaker, this bill again looks at strengthening the office of the Registrar of Political Parties, which is a very, very welcome move. I will not go into the other issues that are very good in this piece of legislation. There's clarity around what is a political party and what is coalition. I will not go into that because Honorable Kanuri has done that very well, and therefore I'll just jump into what, as the Center for Multi-Party Democracy chairperson, I see as very progressive provisions within this, especially as regards strengthening of the office of the Registrar of Political Parties. Mr. Speaker, party organizational structure and processes are important in the functioning of parties. Mr. Speaker, I therefore, in this regard, the proposal to review the regulatory framework to provide for an administrative mechanism to ensure routine monitoring and supervision of political parties in particular and parties generally, to ensure adherence to laws, party constitutions and rules and procedures, such a welcome and progressive provision in this. So I think when we have a strengthened office of the Registrar of Political Parties, we will then be able to enforce the constitutions of our parties and have sustainable parties in this country, Mr. Speaker. Hence, the proposal again, in this bill, we've seen that the bill proposes to strengthen the role of the Registrar of Political Parties, very reasonable, in order to give the office more teeth and enable administrative capacity of the office to enable to rein in Kenyan parties. Mr. Speaker, we have almost 100 parties now. We had 89 as of just a few weeks ago. With a few ones now, we have over 90 political parties. And if the office of the registrar has no teeth to make sure that whatever rule of law as pertains to political parties is not adhered to, then we will be going round in circles. And so this piece of legislation, Mr. Speaker, is welcome, especially for me as a chairperson of the Center for Multi-Party Democracy. There could not have been a better bill to ensure that our political and democratic process is strengthened, is sustained, it becomes sustainable. I support, Mr. Speaker.
Senator Cherargei.
Mr. Speaker, thank you for this opportunity to contribute of this. From the onset, I want to say that I've looked at the committee report. I think during my time as the chair, JLAC, I never produced a contradicting report as such. Because when you look at the decisions and arguments that have been made by the committee, it looks like the committee was given with instructions not to touch anything. Because in any case, when you seek at the submissions of the IEBC, Mr. Speaker, is that even if you read curricular report, the curricular report was very clear that his elections, Mr. Speaker, and I wish the Deputy Majority Leader would keep quiet so that I can concentrate.
There's an intervention from Senator Mogeni.
Yes, Mr. Speaker, I have a tremendous respect for my junior, Senator Cherargei, and he did a very good work as a chair of Justice, Legal Affairs and Human Rights. But Mr. Speaker is making some remarks on the floor without substantiating. He is saying, Mr. Speaker, that I was instructed to write this report in the manner it has been presented. And Mr. Speaker, that is far from it. Mr. Speaker, the report that I've presented is a result of a very heavy workload on the committee, having had presentations from the public and given due consideration to all the views that were presented to the committee and analyzed the Constitution. So is he in order, Mr. Speaker, to make that wild allegations that I was given instructions to write this report the way it is without substantiating?
There's another intervention from Senator Pareno.
Thank you, Mr. Speaker. I was going to ask Mr. Speaker that you rule out, you rule on what the Senator Cherargei has just said by imputing improper motive on a properly constituted committee of this House by saying that they have been instructed. He either substantiates or he apologizes to the Honorable Senior Counsel and the Legal Committee of this House and the House at large.
Yeah, I see other interventions. I don't know whether they're still on the same. Senator Nderitu, before I make a ruling.
Mr. Speaker, I listened to Senator Cherargei, and he said the report is contradicting. And he's the one who was reading that report. It is up to him to say whether he's being contradicted by the report or not. So it is up to, I don't think there's anything out of order. He's the one who's reading the report, Mr. Speaker. So he's the person who is, he's the one who was reading. It is not the chairman, he's the one who was reading the report.
There's another intervention, Senator Farihia.
Mr. Speaker, I just want to bring to your attention, Mr. Speaker, I have sat in this House. Every time Senator Cherargei contributes, he always accuses a senator in this House, and it has become an habitual problem. So, Mr. Speaker, I think you need to address this decisively, and let us have a proper decorum in this House. I thank you, Mr. Speaker.
Senator Ngugi.
Thank you, Mr. Speaker. Mr. Speaker, I think you need to rule on this matter because I'm a member of this committee that generated this report, and everything that we did, Honorable Speaker, we did in accordance with the rules and laws of this House. Mr. Speaker, we spent a lot of time on even having public participation. We received memoranda from around 25 groups. We retreated to consider each and every matter that was raised. And therefore, for the Honorable Member of Nandi to say that we were directed to write our report in a certain way is out of order.
Okay, Senator Chila Yako.
Thank you, Mr. Speaker. Mr. Speaker, you heard what Senator Haniri said about his experience in the House. I also want to add that. Now, is Senator Cherargei in order to start things that might lead to the behavior the National Assembly had last time? Mr. Speaker, if that is the path of debate he is taking, attacking members and accusing them of bad behavior, this House is made up of human beings who can go mad. So, Mr. Speaker, would I be in order to ask you to be firm with Senator Cherargei so that we do not degenerate into chaos?
Senator Mazayo Stewart.
Asante Bwana Spika. Bwana Spika, nimekuwa hapa nikimsikiza ndugu yangu Cherargei, lakini nafikiria heshima si utumwa, kwa sababu yule ambaye anamwambia namna hiyo ni kiongozi alikuwa anaongoza hili jopo la sheria na walifanya kazi yao kisawasawa. situmaini kama kuna mtu aliweza kuwafuata na kuwaambia waandike ile ripoti vile itakavyokuwa. Ni makosa ama sio haki kuweza kuchezea majina kwa sababu umeketi hapa mbele ya bunge na hakuna hatua yote inaweza kufanywa kuchafua majina ya maseneta wengine. Je, nataka kuuliza Bwana Spika, ni haki ya yeye kutamka mambo ya uongo kama hayo?
Honorable Senators, I think I want to give a direction. Senator Cherargei, you can read the mood of the House. And please, let's not concentrate on things that are going to divert us from discussing the main issue that why we are here. Just take care of what you are saying, because these are colleagues, and when you cast aspersions on a senior counsel like Senator Omogeni, senior counsel James Orengo, who are in that committee, I think I leave it to your conscience. Please don't go that direction.
Mr. Speaker, I think also it's important that we should not criminalize anybody's opinion, because I just say the report is contradicting, because when you look at the issue where it was being...
Yes, Senator Orengo.
But I have not said anything, Senior Counsel.
Okay, take your seat.
Mr. Speaker,
yeah.
When there is a violation of the standing orders and the honorable member is imputing improper motive, and you cannot impute improper motive until you have a substantial motion. And, Mr. Speaker, it's so bad. Senator Omogeni, senior counsel, he brought a report here on BBI that is being commended universally. If you read this report properly and you went to the right law school, you will find that this report... Mr. Speaker, the member was chair. He was a member. He was chairman of the legal committee during his tenure. No such report ever came to this House. It was mundane. It was a report that it cannot be even taken into account the Assembly. But since he has imputed improper motive, he has either apologized and withdraw, or, Mr. Speaker, you tell him to stop from speaking.
Okay. Okay, Senator Cherargei, take your seat. Take your seat. I want to invoke standing order number 96-4, which says no senator shall impute improper motive to any other senator or to the member of the National Assembly except on specific substantive motion of which at least 3 days notice has been given, calling in question the conduct of that senator or member of the Assembly. And 97 says, a senator who has used exceptionable words and declines to explain or retract the words or to offer apologies for the use of the words to the satisfaction of the Speaker shall be deemed to be disorderly and shall be dealt with in accordance with the rules pertaining to the disorderly conduct. Therefore, given what I had, I want you to withdraw and apologize to the Senate.
Mr. Speaker, I wish to withdraw and apologize, but with a rider that the fact that you are senior, there is nowhere that you must demean anybody. Respect is a two-way traffic. Even if I am young, you must respect me. Yes. So, Mr. Speaker, what I was saying, this report is contradicting, because when you look at clause 28 of the bill, it says that appeals can end at the Court of Appeal. But the committee finds it's not wrong to say, as the Constitution provides, the appeal can end at the Supreme Court, Mr. Speaker. We are aware, Mr. Speaker, that the main aim of this law, Mr. Speaker, is for some few individuals within that they want to process their own things, like what they are trying to do with some formation called Kuzimia, Mr. Speaker. So, Mr. Speaker, when you look even the power that registrar of political parties have been given, Mr. Speaker, is these powers are unnecessary, because when you look even at party rules and regulations, Mr. Speaker, that were provided by the IEBC in 2017 is still in force. Why are you bringing registrar of political parties, Mr. Speaker, to come and micromanage even party primaries? And Mr. Speaker, if these people allow, because I can see they have been instructed, and instructions are not bad, Mr. Speaker.
Senator
even
Cherargei.
can instruct
Order, Senator Cherargei. Order. Live to the expectations of this House. Senator Cherargei, I'm warning you, please.
Instructions are not bad, even as we receive instructions from citizens. So I should not use the word instructions.
When you say they have been instructed, by who?
By wananchi. Mr. Speaker, Mr. Speaker, and I want to say on the floor of this House, if we don't take care and allow registrar of political parties to micromanage by producing party lists, most of the people here will become the victims of party primaries if they allow that route to go, Mr. Speaker. Mr. Speaker, we are aware that this thing, even when you look at the coalition and political parties, Mr. Speaker, that has been given, when you look at the issue of political parties fund, and I heard my brother talking about it, they are the culprit, Mr. Speaker. They are the ones that in NASA, they ensure that they frustrated other political parties by ensuring that they do not get their funds, Mr. Speaker. So there is no way that you can give even the audit of political parties. Because the Auditor General, Mr. Speaker, or Attorney Auditor General in terms of auditing does not nullify. Therefore, why are you bringing duplicity to the law, Mr. Speaker? Mr. Speaker, the fourth point that I want to make is on the definition of political parties. Mr. Speaker, it is sad. And this weekend I was in neighboring place called Kibukat next to Kisumu County, Mr. Speaker. And they were wondering if they have their local society, circle, can they become part of political parties? So in as much as Senate should rise up to the occasion of debating this thing with sobriety, the report is disappointing. It does not even live to the standards, Mr. Speaker, that we would have expected, Mr. Speaker. So even if, and it will be embarrassing to the Senate, even if, I'm using the word even if, this bill is passed, we will be embarrassed by the courts of law because these amendments are unconstitutional, illegal, and they are being used, Mr. Speaker, by a few individuals to fight political wars, Mr. Speaker. I'm not saying that the laws shall not be made or amendments cannot be brought, but it should not be an excuse to allow a constitutional process. I reject it, Mr. Speaker.
Senator Wambua.
Thank you, Mr. Speaker. Mr. Speaker, I'm very encouraged by the direction you have given Senator Cherargei that in debating this bill, we must live to the expectations of this House. Kenyans out there expect a sober, candid debate on this matter, and that's what I stand to do, Mr. Speaker. Mr. Speaker, I must say from the onset that I support this bill, but with amendments. Mr. Speaker, I am very encouraged by the provisions of this bill, especially on the issue of political parties funding. Mr. Speaker, this country knows that my party wiper has been a victim of betrayal by a coalition partner who has been unwilling to share political parties' funds. Now, with the passing of this bill, if it will pass, the distribution of funds to political parties will not be left to the decision of leaders of political parties. It's in the law, and funds will be shared in accordance with the provisions of the law. The Speaker, this bill is also progressive in terms of defining pre- and post-election coalitions, including going to the extent of coming up with a coalition political party. Mr. Speaker, having said that about this bill, there are provisions in this bill, Mr. Speaker, that I find offensive to democracy and a contradiction with the Constitution. Mr. Speaker, Article 229 of the Constitution, which is the supreme law, gives the Office of the Auditor General the powers to audit political parties. And it is explicit. 229(4)(f). It's explicit that the Auditor General shall audit the accounts of political parties that receive public funds. Speaker, this bill, Section 21, proposes to exempt political parties from being audited by the Auditor General. Speaker, that's a direct contradiction with the Constitution, and a way must be found to cure that mischief. Mr. Speaker, the other issue that I have with this bill is on the issue of the role of the registrar of political parties in party primaries. Mr. Speaker, there is a problem with that. Because what we are trying to do is, we are giving too much powers and too many responsibilities to the Office of the Registrar of Political Parties to even try to, I will not say it micromanage, but to get involved in the primaries of political parties. And then the question would be, in the event of a dispute within the political parties, and after they have even exhausted their internal mechanisms of dispute resolution, what will be their recourse if the registrar of political parties is a member or is part of the processes of party nominations? Mr. Speaker, that issue also needs to be cured. Mr. Speaker, those will be my remarks on this bill, but I want to say something about the report, Mr. Speaker. This report, the team did a good job. For reasons best known and agreed among the committee members, they found no reason to propose an amendment. Mr. Speaker, I do not want, and I will be the last person to cast aspersions on any member in this House. But, Mr. Speaker, it does not reflect very, very well on us as a House that when there are glaring contradictions between the proposed amendments and provisions of the Constitution, the committee did not find it necessary to cure that mischief at this stage. The Speaker, with those remarks, I support the amendments.
Senator Sakaja.
Thank you very much, Mr. Speaker. Mr. Speaker, I want to state at the outset that, Mr. Speaker, I support this bill. Mr. Speaker, I participated in the committee. I'm a member of the Justice, Legal Affairs and Human Rights Committee, and we had several deliberations. So I support it for two reasons. As it is, without amendment of a single comma or a full stop. Because, Mr. Speaker, the Waswahili say, mtoto akililia wembe mpe, akijikata ni shauri yake. Mr. Speaker, this bill has a number of issues. And these issues were discussed. In fact, the decision to have the bill as it is was a very, it was a decision that took a lot of processes. But, Mr. Speaker, there are certain things that have been raised that any member, and I know the chairman had a lot of, concern as a professional, and I'm sure he's spoken to it, or I don't know if he's already spoken to it, he will not raise it. Because, Mr. Speaker, it's a political parties bill. Political parties bill it's about politics and about parties. Mr. Speaker, I have chaired a party. And I know the intricacies of leading a party. Sometimes when something comes to the floor of this House, we find that we have made a law that is not the best law because of the vagaries of politics. Only later to realize the trap we've put ourselves in. And I will give a few examples to members. It's really good, and I'm glad we're in the Senate. Because in the Senate, we listen to each other. Even if it's from opposing politics, we say even a broken clock is right 2 times a day. If it's stuck at 7, it is right at 7 a.m. and it is right at 7 p.m. So it's good to listen to each other. Mr. Speaker, the first thing, the registrar has been given a lot of power to make decisions on subjective issues without a criteria. This power to make decisions on subjective issues, Mr. Speaker, like ideology, like there's no criteria. And in fact, we wanted to say, let it point to Article 91 in the Constitution, that that is the criteria for registering a party. So if she does not like the ideology and there's no way to measure ideology, your party may not be registered. The registrar of political parties does not have a role to play when it comes to elections. That is the constitutional mandate of the IEBC. And that is a provision that, Mr. Speaker, can be challenged in any court, you know, especially when there's duplication in the roles of the registrar and the IEBC. The IEBC is the only one with a role on elections. But, Mr. Speaker, there is one provision that we even challenge the registrar. And I'll ask members to listen. They might become victims of this. Mr. Speaker, section, I think, 38 says that the registrar is the one who will give parties a certified copy of the register to use during nominations. And then, and Mr. Speaker, many here have experienced it. You've gone for nominations or elections, your name is missing. Kenyans have been complaining they find their names in other parties. So your name as a candidate might be missing, but that is a register certified by the registrar. You will have no time to deal with it. Number two, it says, if an unmember, in fact, it says someone who's not a member of your party cannot participate in nominations. Yeah? Senator Pareno has been a director of elections. You know how it is. In 2013, as chair of TNA, we registered 6 million members. We sold 6 million cards at 20 shillings. Because we told our members, or Matangi, remember, that if you don't have this card, you will not participate in the nomination. Until the day of nominations, the registrar could not give us a copy of our register by polling station. Because you need the register by polling station. When she came here, she said she can only give us by ward. Now, if you have a register in every ward, one register, surely, those names are in every polling station in the ward, people will just go around in buses. Number two, Mr. Speaker, if I show an unmember of Senator Omatangi's party participating in your nomination, you'll be disqualified. I'll get you disqualified. The essence of this bill, Mr. Speaker, I know, was to cure the problem where you have a coalition, and in the coalition, for instance, in the last election in NASA, Raila Odinga and the Kalonzo Musyoka were on an orange. So you don't want to do that, because Kalonzo Musyoka comes from Wiper. The solution would not be to create a coalition party. The solution would be to say that where a coalition has fielded a joint candidate, allow the coalition or the candidate to use the logo and the slogan of that party. Mr. Speaker, please allow me just 2 minutes. I'm making points and they're listening. Kindly.
Okay, just 2 minutes.
Mr. Speaker, if you did that, then you would sort out the issue, because Article 38 says every Kenyan can join a party. But now you've created a section, a category of political parties that an individual Kenyan cannot be able to join. So it is going to be challenged. But finally, Mr. Speaker, because I have a lot more to say out of experience. Mr. Speaker, tomorrow you will go for nominations in Bungoma. You're in a coalition. You win the nomination and you get your ticket of ANC or Ford Kenya, or whichever party it is. The person you have defeated will go and get a ticket of Azimio la Umoja or of the coalition you're in. How do you prevent that, Mr. Speaker? Mr. Speaker, it might happen in Mombasa to Senator Faki. You have won the ODM nomination, somebody comes with a coalition ticket. And that coalition ticket, Mr. Speaker, of course the coalition agreement can speak to it, but by the time you have solved it, it will be an election petition. Everybody will want to vote for a candidate who is on the party of the flag bearer. We should have limited the use of coalition party to presidential election, Mr. Speaker. There are many issues in this bill, but Mr. Speaker, today, because when this bill was being formulated, they thought there would be a challenge or a contest, because maybe one side thought they're the ones who need it. I want to say categorically, even us, we need it more than you. We now need it. You're forming a coalition party, we're also forming a coalition party. What is good for the goose is also good for the gander. These laws won't be applied to only one side of the elections. It will be applied to both sides. If it's a bad law, it is going to be bad for everyone. If it is a good law, it is going to be good for everyone. So, Mr. Speaker, with that, I support this bill.
Senator Agnes.
Thank you, Mr. Speaker. From the onset, I support this bill. And I want to say that our country is as vibrant as its political parties. And Kenya has over 70 political parties and increasing by day, well regulated. So the order in those political parties finally creates the order that is needed in a country. I think this bill is coming at the right time when we are moving towards elections and looking at various coalitions. For a long time, Mr. Speaker, most coalitions have had problems and haven't had a way to resolve those problems. The registrar, for example, would say, go to your coalition agreement and then follow that agreement. But we also have provisions about coalitions and sharing, for example, where certain specifications have been put as to the number of MPs, for example, who are there, as to the numbers of people who are in that political party, and the provision. So that has created a gap. And some of the issues you've seen within political parties are issues that can be resolved and have been resolved to a large extent, but probably they need to have this resolution in writing. Mr. Speaker, this bill addresses key issues, as has been said, definition of political parties, timelines for provision and full registration of these political parties, how to resign and how to expel members from the parties, certification of political parties, etc. And all these are within the amendment bill. For example, at clause 2, the definition is very clear on various...
Let's consult in law terms.
On various identifications.
Order, senators, let's consult in law terms.
For example, what is the political party, party nominations, and especially coalition political parties. At 14A, Mr. Speaker, key provisions are made for rules and functions of political parties, including some that haven't been very obvious over time. For example, 4G, where political and they must be able to articulate, the political parties must be able to articulate in public their policy, and that it provides this policy to members and it can be well identified. Clause 7, Mr. Speaker, coalition political parties will be given a certificate, and I think this will help to a large extent. In the previous regimes, we had coalition political parties only with an agreement but without a certificate, therefore lacking that identity. And then political funding also will be stipulated, as I said, within coalitions, and the registrar will be given powers to be able to act according to that agreement. Mr. Speaker, that means there's still a big provision that has been put into place for the registrar to play a role in the interpretation of the agreement. But more important, because most of the issues have been raised across financial issues, the registrar will be able to solve that, and stipulations have been made about the distribution for the various political parties. Probably, Mr. Speaker, one of the important things about the discussion for this particular law is the amendment of this law.
Senator Mazaya, what's your point of order?
Thank you, Mr. Speaker. Mr. Speaker, I want to call for the closure of the debate under 104. Can I call the mover to reply? And I want to ask my sister Pareno to support.
There's a member who was on her feet. We'll let her finish, then I give you the intervention. Okay.
I was just saying that apart from the provision and the various amendments that have been made, lots of very vibrant discussion has come up. And from even some of the discussions that are coming, we know that legislation is not a one-time issue. It can always be amended over time. And in the report, certain specific issues have been put. For example, the threshold that political parties should meet to qualify for public funding. This is very key. Duplication and overlaps in mandate of dispute resolution fora arising from political party primaries. Ensuring equality in treatment of political parties by, among others, subjecting existing political parties to the requirement in the bill that new parties need to comply with prior to registration. And last, funding of political parties liaison committee. All these issues are important, Mr. Speaker. Some have been directly addressed in the bill, and many more will create very vibrant discussion, both at the level of political parties and the registrar. I thank you, Mr. Speaker.
Order, senators, order. Maybe before order, Senator Cherargei. Before I give that, thought I would give a chance to the Senator Mogeni, who was the chair, just to address the Senate, and then I give you your intervention.
Thank you, Mr. Speaker, for also giving me a chance to make my contribution. Mr. Speaker, first, I want to thank all the members of my committee and the members of the Secretariat and members of the public who responded to our public invitation to give their views on this particular bill. Number two, Mr. Speaker, I've listened. By distinguished senators, and Mr. Speaker, that's how debate should be. My learned friend, Senator Cherargei, must not agree with the contents of our report, and I think he has all the freedom to provide an alternative view on the floor of the Senate. But what I want to assure the House, Mr. Speaker, that we have complied with the Constitution in the process of processing this bill. Mr. Speaker, we did comply with Article 118 in that we invited members of the public to appear before our committee and make their presentation. And Mr. Speaker, if you look at the annexed memorandum that we received from the public, out of 25 bodies and individuals that appeared before us, 21 of those public bodies, civil society, professional organizations, and individuals are in support of this bill. Mr. Speaker, that is on record, Mr. Speaker. It's on record, Mr. Speaker, and I would have wished my learned friend, Mr. Cherargei, a former member of this committee, to sit in and listen to the views that were expressed by members of the public. And Mr. Speaker, even the political parties that appeared before this committee are very happy that for once there is going to be good management and distribution of the political funds, Mr. Speaker. So largely, Mr. Speaker, from the civil society, from political parties, there is full support for this bill. And Mr. Speaker, some of the provisions are they are trying to answer an obligation that has been placed in this House. Mr. Speaker, under Article 87(1), Parliament has an obligation to pass legislations that can guide timely resolution of electoral disputes, Mr. Speaker. That's why, Mr. Speaker, this bill is trying to amend the Political Parties Act by increasing membership of the political parties' appeals tribunal so that we have an expanded number of commissioners from the current 7 by adding another ad hoc 18 so that most of us will find ourselves having disputes emanating from nominations. You can have a timely resolution of such disputes before the political parties' disputes tribunal. Mr. Speaker, all the other issues are around issues touching on notice of political parties, Mr. Speaker. We have provided our reasoning in the report by saying that where the Constitution is very clear, a statute cannot, of course, limit powers that have been donated to a constitutional body. In terms of, Mr. Speaker, political rights, we have answered in our report that this bill can never take away the power of courts to protect fundamental rights of citizens. So even where one feels that this bill will infringe on the rights of that citizen, you have a right to go to court. Finally, Mr. Speaker, we have traveled in so many around the world looking at best practices from many jurisdictions, Mr. Speaker. This issue of funding for political parties, Mr. Speaker, we had a Ghana political party appeared before us, Mr. Speaker, and the chairman of a Ghana political party, in fact, made a very strong case that every party that is registered in this country should qualify to get funding from the state. And Mr. Speaker, if you go through our report, we have given comparative analysis on what happens in countries like United States of America, in Germany, and other countries. So it's a report, Mr. Speaker, that does not confine itself to Kenya, but even the best practices from other countries. Of course, Mr. Speaker, the impression I've formed is that my good friend, Senator Cherargei, did not go through the entire report, but if he takes time to read through the report and make an attempt to read how you interpret and apply the Constitution, you will be of a different view. Mr. Speaker, I support.
Senator Mazayo.
Thank you, Mr. Speaker. Mr. Speaker, the point I was raising on was that the mover be now called upon to reply. I now call, I want my sister Pareno to second me. The point has been raised.
What's your intervention?
Mr. Speaker, when you look at the...
Order, she has to second first, yeah.
I second, Mr. Speaker, that we now call upon the mover to respond.
What's your point of order, Senator Cherargei?
Mr. Speaker, when you look at the standing orders of the Senate, it talks about the leave of the Senate, means that that with the support of 2 senators, we can seek the leave so that I can see some of colleagues still want to contribute to this important bill, Mr. Speaker. We cannot rush. I agree that some people would want to rush this process, but in the interest of the country and in the interest of ensuring that the legislative process is respected, Mr. Speaker, it is not in so good faith to say that the mover be called to reply. I want, Mr. Speaker, that you rule them out of order and allow as many colleagues. Mr. Speaker, you gave us 5 minutes. You say the reason you gave us 5 minutes was to ensure that everybody has a chance. Let the majority have their way, but also minority have their say, Mr. Speaker. And it is important even for history, Mr. Speaker.
Oh, okay, just a minute. Because I'm going to propose the question, you will then raise those issues after I propose the question. Let me propose the question. Okay, what is it, Senator Murko?
Mr. Speaker, whoever makes such a proposal is bringing shame to this country. Mr. Speaker, you made a clear communication to this House that we called for a special sitting because we considered political parties amendment bill a very serious motion in this House. Mr. Speaker, in your communication, you said this House is a sober House. Everybody will get 15 minutes. Everybody contributed, including the minority leader, who said, Mr. Speaker, the debate on this motion must be given due consideration. Mr. Speaker, if we were coming here to rush, first to limit time to 5 minutes, then, Mr. Speaker, to move ahead and cut short, Mr. Speaker, that debating time for this very important bill, Mr. Speaker. Mr. Speaker, then why did we come for a special sitting? Why did we have to call the House? Mr. Speaker, I know my colleagues are here are in the majority because maybe they will steal their way, they will pass this bill. Mr. Speaker, there are glaring and clear and constitutional provisions on this bill. We want to speak on these issues for the record. We want them when they win, Mr. Speaker. We will know we will meet them ahead, but we must be given a chance to, Mr. Speaker, put the things we have raised on record. But if we are coming here as a Senate, we say we are going to behave maturely. We have cut time to 5 minutes. We are going ahead to say we are now going to reply because we want to rush the process, Mr. Speaker. I tell you, Mr. Speaker, for purpose of history, history will record that we actually, Mr. Speaker, in a very shameful way, took the people of Kenya for a ride. And therefore, Mr. Speaker, since it was clear on your communication, Mr. Speaker, and the communication of the Speaker was made under pursuant to standing order number 1. Mr. Speaker, notwithstanding the provisions of the standing order, notwithstanding, Mr. Speaker, the right for anyone here to call the mover to reply, including the provision of standing order on that issue, Mr. Speaker, which I agree, it is clear. Mr. Speaker, I think your communication supersedes it. Otherwise, your word, Mr. Speaker, will not be your bond.
Order, Senators. You know I respect the standing orders of this House. And when a member stands and makes talks, then I also have to respect that. So I will propose the question, and after that, you will be able to contribute what you want. I now propose the question, which is that the mover be called upon to reply. Okay, I now put the question. Order. Okay, yeah. Okay, order. Okay, Senator Sakaja, what is it?
Okay. Thank you, Mr. Speaker. You know, sometimes when something is not being prosecuted in a fair way.
Okay, you know, let me intervene a bit. Just a minute. There are many people who had already put the card, so I don't know who wants to speak at this point. Okay, so continue. Then you will raise. Okay. Senator.
Thank you, Mr. Speaker. What I was saying earlier, and if you had my contribution at the earlier point, I said that sometimes when something is so politically charged, you refuse to listen to the sense of the other side. Democracy is such that the majority has their say, the minority, has their way, the minority has their say. This is a house of debate. Mr. Speaker, the word parliament comes from the root word to parlay, balance. But if you're stifling it because you want to pass the bill, rest assured it will pass. I have stood and I've said I support it as it is. But we cannot reduce the Senate to a house where even such an important bill on political parties, you're going for nomination soon. You're going to vie on political parties. You don't want even to debate because of, I don't know what reason. Mr. Speaker, we must not stifle debate in this house. The outcome will be a democratic outcome, Mr. Speaker. In fact, you will be shocked on which lines people are going to vote. Because as I said earlier on, Mr. Speaker, if it is a good bill, it's good for everyone. If it's a bad bill, it is a bad bill for everyone. Let us not reduce the Senate into such a house. So, Mr. Speaker, I would urge that every member who wants to contribute to this bill be allowed to contribute. And Mr. Speaker, I feel very sad. You noticed earlier, Mr. Speaker, when I was contributing, members were keenly listening. I had only 5 minutes. I wish I had more, because I would tell them the pitfalls of this process. Do you know, Mr. Speaker, when you go to nominations, you'll be alone. You won't be in this Senate. You'll be alone in your constituency or in your county, dealing with a party office in Nairobi. And you'll remember what you passed, Mr. Speaker. You'll remember what you passed in this house. So I would urge members sometimes, in as much as there is political pressure or whatever other motivation, be very wise. Be very wise in the decisions you make. Let us have every member who wants to contribute. You'll make your decisions. In fact, Mr. Speaker, some of the proposals we had made, even some of which I saw in the National Assembly, I promise you if members had sat across a table, removing the mistrust, there would be amendments to improve this bill that people would agree on. But because it is said that it must be passed like that without amendments, the result will be for all of us to face, Mr. Speaker. So I urge
Senator
that
Mohamud.
the mover not to be called to reply. I oppose the motion for the mover to be called to reply. Let everybody contribute.
Senator Mohamud.
Mr. Speaker, we have been called here for a special sitting for 3 days, Tuesday, Wednesday, Thursday. In fact, the notice was very clear that today, yesterday, we sit at 2:30, and tomorrow we'll sit from 10 in the morning and in the afternoon also. The reason being that we have a special motion, a very important motion before us, before this country, which was actually debated in the National Assembly and brought to us. Now, it's unfortunate that we want to rush that, to the extent that, we want to gag members and to go to vote now. Mr. Speaker, sir, whereas the majority might have the way and win the vote when it's put, it's important that members of this House be allowed to ventilate and speak to this motion. The nation is watching. This House is a house of decorum. This House is a house of maturity. We will not, because, there was a lot of problems in the other House fighting. We are not fighting, but we are fighting in a very indirect way. Fighting by gagging people who they think they are in a minority. So, Speaker, sir, it will be very unfortunate, and very unfortunate also for my colleague from Cliffy, a retired judge, to bring that. In fact, it should not have come from him. I will urge that this House be allowed to debate the last person when it's exhausted. In fact, if 5 minutes was the rush. Because when you say 5 minutes, Mr. Speaker, sir, without trying to, trying to challenge your ruling, already I thought there was something in the offing, that the thing was rushed to us, we can be able to vote. I expected us to vote tomorrow. Tomorrow. Not today. Mr. Speaker, sir, I object to the mover being called to reply.
Order. When I said 5 minutes, I said I wanted to give people an opportunity, as many people as possible, to talk. Wait, Senator Murkomen. Order, Senator Murkomen. Order, Senator Murkomen. Order, Senator Murkomen. I said, and I want to repeat, listen to what I said. I wanted to give an opportunity to everybody to say. But I'm also following the standing orders. When somebody proposes, I also have to listen to everybody. I have to be balanced. Senator Nderitu.
Bwana Spika, asante. Ni jambo la kuvunja moyo sana ikiwa siku ya leo na sisi tulikuja hapa tumejihami kujadili mswada huu wa vyama kwa sababu ni mswada ambao umezungumziwa katika bunge lile lingine kwa mapana na marefu. Na sisi tulidhania kwa sababu jumba la Senate na ulipokuwa ukituita ulituambia vizuri tutaongea kwa marefu na mapana. Lakini nimestuka sana wakati ndugu yangu Senator Mazayo ameamka na kusema ya kwamba angetaka tuwache kujadili mswada huu. Kila mtu anataka kuongea kuhusu mswada huu. Na Speaker, ulituambia vizuri ya kwamba watu wengi wamesema ya kwamba wangetaka kujadili mswada huu maseneta. Sijui imekuaje sasa ya kwamba tunataka kuvunjilia. Kweli wa mambo ni ya kwamba sisi tunapaswa tusikizwe na tuseme yale ambayo tunapaswa kusema kwa sababu mswada huu tunaona uko na makosa na unapaswa kupigwa msasa. Asante Bwana Speaker.
Okay, order, senators, order. Using, just a minute, using my discretion before I put the question, I will allow a few senators to speak. Senator Murkomen. Bill. On the bill. You know everybody's talking, I can't hear what, please, let's have some order. Okay, continue.
We speak on the bill.
You speak on the bill.
Okay. Meaning, Mr. Speaker, thank you, Mr. Speaker, for using standing order number 1 to vary the motion on the time. Mr. Speaker, this bill is very critical and very important for us, particularly those.
Okay, order. There is order. There's a bit of confusion. Order. Please, let's. Yeah, procedure. Something on procedure. Yes. Just a minute. What is your point of clarification, Senator?
Mr. Speaker, I thought what Senator Stewart Mansah raised was on a procedural motion. So, yeah. Mr. Speaker, I thought we were still contributing on the motion.
Just a minute, we are consulting a bit. Okay, order, senators. Order, senators. So, after consultation, we'll have to finish. I'll have to propose and put the question. Then after, order, Senator Cherargei. Relax. Then after that, I'll use standing order number 1 to allow for a bit of debate on the bill. Okay. So I now put the question, which is that the mover be called upon to reply. As a matter of that opinion, say aye. As a matter of the conduct of you, say nay. The ayes have it. So okay, order. Okay, order. Order, senators. So I now want to allow a few senators to contribute. Then we move. 5 minutes. Senator Murkomen.
Mr. Speaker, thank you very much. I will not go back to what happened before this, but I'm happy with your decision. Mr. Speaker, this bill is a terrible, hopeless, useless bill, Mr. Speaker. This bill fails all tests. It fails the test of drafting in terms of language. It fails the test, Mr. Speaker, of corresponding with other bills, including the Elections Act. It also fails miserably the constitutional test. First, Mr. Speaker, I'd like to say that on the part that deals with removal of a member, or a member being deemed, Mr. Speaker, to have been expelled from a political, to have, Mr. Speaker, resigned from a political party or expelled from a political party, Mr. Speaker, that part is improperly drafted. Not so long ago, our colleague, Senator Manyora, was expelled from this House. And Mr. Speaker, from his experience, I have proposed an amendment. Mr. Speaker, we need a situation where if a member is expelled by his political party, that political party should not collude with the registrar of political party and, Mr. Speaker, government printer to degazette that member quickly. I have proposed, Mr. Speaker, that we must give 21 days notice for that expulsion to take effect and give the member the right to take, Mr. Speaker, any legal processes and measures that will ensure that they defend themselves. Mr. Speaker, on the part that the registrar is being given more powers, I disagree entirely. Mr. Speaker, elections under the Constitution, Mr. Speaker, is a function of IEBC. Unfortunately, Mr. Speaker, because some people want to micromanage, Mr. Speaker, political parties, they have given ORPP the responsibility to manage political parties in terms of verifying, Mr. Speaker, registers, in terms of, Mr. Speaker, giving specific timelines, in terms of, Mr. Speaker, constricting what register the political parties are going to use. Mr. Speaker, this is a hopeless provision. I am so glad. And, Mr. Speaker, I want to speak here with no fear of contradiction that, it will be shame tomorrow when the courts look at these provisions, Mr. Speaker, of this bill and say that there were 3 senior counsels. There was Amos Wako, there was, Mr. Speaker, Omogeni, there was Orengo, and many other senior lawyers in this House who could not see the very clear provisions of this bill that, Mr. Speaker, try to take away the responsibility of IBC and give it to RPP. Mr. Speaker, give me just 1 week or 2. These things will be declared hopeless. And, Mr. Speaker, therefore, I would like to say, I want to go on record, Mr. Speaker, as one senator will say without fear of contradiction here, that the powers being given on registrar here should be deleted, to be removed, because, Mr. Speaker, registrar has no business managing elections. It's even as ridiculous, Mr. Speaker, to the extent where the registrar is being given powers to manage independent. This is a registrar of political parties that is being told to allocate signs, Mr. Speaker, to independent candidates of which symbol they are going to use in elections, which is a direct responsibility of IBC in terms of processes of elections. Mr. Speaker, I have made clear proposals that these areas should be removed and be deleted, Mr. Speaker. Mr. Speaker, there is also provisions in this bill that, Mr. Speaker, try to create a definition, a new definition of what is a political party. There is, Mr. Speaker, some oxymoron being created called coalition political party, a very useless oxymoron. The definition of what a political party is in Article 260 of the Constitution, and it's it is, Mr. Speaker, on the bill, the chapter, Mr. Speaker, that deals, Mr. Speaker, with elections. And, Mr. Speaker, that part of the Constitution does not anticipate a situation where political parties will have two identities, as a party of a group of parties called a party, and also still have a capacity to stand alone. You are either a political party or you are, Mr. Speaker, a coalition. And, Mr. Speaker, you know, I laugh at, because most of the people here who are expediting this process to have this thing called, this oxymoron called coalition political parties, Mr. Speaker, I'll really laugh at them tomorrow, because I know all of them are being herded together to forget about their political party so that they can be put into one basket to confuse the republic that there is another party, even though it's ODM in another color. And, Mr. Speaker, that kind of process will only lead to many of these candidates who are here crying tomorrow. I remember in 2016, we were here, we debated 2017, we amended the Constitution, the Mean Elections Act, we went for the nomination. Mr. Speaker, victims of that law, Mr. Speaker, the people who wanted us to ensure that independent candidates will not have a chance after going through nomination. Mr. Speaker, the first person to be denied ODM certificate was the late Jacob Midiwo, who was a leader in the National Assembly. And so I will not be bothered, I will not even be worried. I wish that oxymoron passes called, Mr. Speaker, coalition, political parties. I know those who will cry here. It will not be you, me and you, Speaker, because I know where you will go. And I know where we will all of us go. It will be those who are here hiding now and saying that we should not debate.
You are out of order, Senator.
Thank you, Mr. Speaker.
You are out of order.
Okay, Mr. Speaker, I respect your ruling. Okay. The Speaker, it's not you, the Speaker. I know where many politicians, including the next governor of Bungoma, will be, Mr. Speaker. They will be on the right side of history. Mr. Speaker, they will be on the right of history. But those who are hiding this process, and Mr. Speaker, anyone watching from Kamukuywa or somewhere in Bungoma should just know that the governor of Bungoma is sitting in this house, but I'm not mentioning names. What I am trying to say is that as colleagues and as senators, as people who are experienced in politics, some who have been here like the man who is trying to be governor of Viga, my friend, what is his name of Kaniri, who has been here for 6 times. What a shame that the day you are leaving the Senate, you become part and parcel of people who are passing this very unfortunate bill. Let us reason together. Tomorrow you will be the ones being expelled. Tomorrow you will be the ones being denied by your Mr. Speaker, Supreme Leader, the certificate. We were told of story. Myself and Senator Cheriot were told of a story of now a governor of one of the counties in Nyanza, who, Mr. Speaker, having been denied certificate in 2007, he was holding the leg of the party leader and begging and rolling on the floor. Mr. Speaker, that time is coming in a month or two, Mr. Speaker. And I know that is a friend of my friend Ohuta. And Mr. Speaker, when Ohuta becomes the candidate and he rolls again on the floor, Mr. Speaker, those victims who are of that bill will be here. Mr. Speaker, I oppose this bill.
Your time is up. Since this is a very limited discretion, Senator Chilo Ayako.
Thank you, Mr. Speaker. Mr. Speaker, I do not know why Senator Murkomen is very annoyed. Mr. Speaker, you should just relax. If this thing is bad, it is bad for everybody. If it is good for everybody. So it's a common denominator that all of us will be facing it. Now, Mr. Speaker, I just want to take 1 minute. Mr. Speaker, I've been in Parliament as a member of NDP, which died. I've also been in Parliament as a member of KANU when the merger took place, which is on the verge of dying. I've also been in Parliament as a member. Sorry, I withdraw. It's not on the verge of death, but it's not doing as well as the ruling party ought to have been doing. Now, Mr. Speaker, I've also been in Parliament as a member of LDP, as a member of NAC, and as a member of ODM. Mr. Speaker, a time comes when people get tired of killing political parties. We need a law that will midwife the existence of political party for posterity and for history. If you look at this law is good. It's allowing parties to survive as a family, as a coalition, and it is able to bring in diversity into it. Mr. Speaker, let us look at it positively. Let us not kill one another because of this. The competition is out there with the voters. Go there and talk to them. Mr. Speaker, I beg to support.
Okay, that was very limited discretion. I now call the mover to reply. We have amendments, and I think you will be able to contribute. Senator Cheriot, what's your point of order?
Much as, Mr. Speaker, even the discretion of the Speaker should be fair. And no, you see, Mr. Speaker, protect me because there are professional other things. Let me not mention.
Very fair, Cheriot. Senator
Yes,
Cheriot.
but I plead with you, just like you gave my colleagues, Senator Murkomen and Achilo Ayako, there are a few of us who had also requested to say something within 3 minutes.
Reply.
Mr. Speaker, I beg to reply. Mr. Speaker, it's been a good afternoon. Members have mentioned many things, contributed. A good number of members have supported. And Mr. Speaker, I wish then to, again, bring it to the membership to pass it, to agree with all of us. Mr. Speaker, Mr. Speaker, it's important that we all agree that the next stage is therefore going to be allow more members to speak when we come to doing the amendments and the committee of the whole and conclude this matter, probably conclude this matter today. Thank you, Mr. Speaker. Now I beg to reply.
Okay. So we are now moving to division. Okay. I now put the question that, which is that the bill be read a second time. So the bill be rang for 5 minutes. Okay, order. Order, senators. Order. I now direct that the bars be drawn. The tellers for the yes is Senator Kwamboka, and for the nays is Senator Cherargei. Okay, order. Order, take your seats. Or use. Take your seat. I now put the question, which is that the Political Parties Amendment Bill, National Bill, Bills number 56 of 2021, be read a second time. So the clerk will proceed, and since this is a matter affecting counties, it will be by delegation. So clerk, proceed.
Second reading, roll call division. Senator Adan Dulo Fatuma, Isiolo County.
I vote yes.
Senator Ali Abdullahi Ibrahim, Wajir County.
I vote yes.
Senator Boy Issa Juma, Kwale County.
Mr. Speaker, Kwale County vote yes.
Senator Cherargei Samson Kiprotich, Nandi County.
Mr. Speaker, on behalf of the great people of Nandi County, I vote no.
Senator Cheriot Aaron Kipkirui, Kericho County.
Mr. Speaker.
Mike? Oh, yeah. I vote no, Mr. Speaker.
Senator Haji Abdul Mohammed, Garissa County.
Mr. Speaker, I vote yes.
Senator Hargura Godana, Marsabit County.
Mr. Speaker, I vote yes.
Senator Imana Malachi Charles Ekal, Turkana County. Senator Kajwang Moses Otieno, Homa Bay County.
Yes, vote, Senator. Okay, they'll come back to him.
Senator Kamar Margaret Jepkoech, Wasingishu County.
Yes. I vote yes.
Senator Kangata Irongo, Muranga County. Senator Haniri George, Vihiga County.
Am I recorded?
Vote.
Mr. Speaker, am I recorded?
Yeah, you vote now.
Yeah, Vihiga votes yes.
Senator Kibiru Charles Rubenson, Kirinyaga County.
I vote yes. Kirinyaga votes yes.
Senator Kihika Susan Wakarura, Nakuru County. Senator Kimani Wamatangi Paul, Kiambu County.
Mr. Speaker, I vote yes.
Senator Kindiki Kithure, Tharaka Nithi County. Senator Kirinyaga Ephraim Mwangi Maina, Nyeri County.
Yes. Have you heard me?
Okay, vote.
Hello?
Vote.
Hello?
Vote. Vote.
Mr. Speaker, Nyeri votes yes.
Senator Langat Christopher Andrew, Bomet County. Senator Lelegwe Tumbesi, Samburu County. Senator Linturi Franklin Mithika, Meru County.
I vote no.
Senator Loitip Anwar, Lamu County. Senator Madzayo Stewart Mwachiru, Kilifi County.
Mr. Speaker, I vote yes.
Senator Mahamud Mohamed Maalim, Mandera County.
I vote no.
Senator Malala Cleophas Wahungu, Kakamega County. Senator Mbito Michael Malinga, Trans Nzoia County.
Mr. Speaker, Trans Nzoia votes yes.
Senator Mbogo George Ochilo Ayako, Migori County.
Mr. Speaker, I vote yes.
Senator Mogeni Eric Okongo, Nyamira County.
Mr. Speaker, I vote yes.
Senator Moi Gideon Kipsielei Towet, Baringo County.
Baringo votes yes.
Senator Mpayei Philip Salau, Kajiado County. Senator Murkomen Onesmus Kipchumba, Elgeyo Marakwet County.
I, Kipchumba Onesmus Murkomen, vote, Mr. Speaker, a big no.
Senator Mudhama Agnes Kavindu, Machakos County.
Mr. Speaker, Machakos votes yes.
Senator Mutula Kilonzo Jr., Makwiny County. Senator Mwangi Paul Githiomi, Nyandarua County.
Mr. Speaker, Nyandarua votes yes.
Mr. Speaker, Taita Taveta votes yes.
Senator Mwinyi Haji Mohamed Faki, Mombasa County.
Mr. Speaker, sir. Cheriot, can you pay attention? I'm voting. I vote yes, Mr. Speaker, sir.
Senator Nderito John Kinywa, Laikipia County.
Mr. Speaker, Laikipia County votes no.
Senator Ndwiga Peter Njeru, Embu County.
Mr. Speaker, I vote yes.
Senator Olekina Ledama, Narok County.
Mr. Speaker, Narok County votes yes.
Senator Ongeri Samson Kegengo, Kisii County.
Mr. Speaker, Kisii County votes yes.
Senator Orengo James, Siaya County.
Mr. Speaker, I vote yes.
Senator Outa Frederick Otieno, Kisumu County.
Kisumu County vote yes.
Senator Pogisio Samuel Losuron, West Pokot County.
Mr. Speaker, West Pokot votes yes.
Senator Sakaja Johnson Arthur, Nairobi County.
Mr. Speaker, I vote yes.
Senator Wako Sitswila Amos, Busia County.
I have to go there? Oh, yeah. Mr. Speaker, sir, I vote yes.
Senator Wambua Enoch Kio, Kitui County.
The Speaker, Kitui votes yes.
Senator Wario Golich Juma, Tana River County.
Mr. Speaker, Tana River votes no.
Senator Wetangula Moses Masika, Bungoma County. Senator Imana Malachi Charles Sekal, Turkana County. Senator Kajwang Moses Otieno, Homa Bay County.
Kajwang vote.
No, you just talk.
He voted. He voted.
So we move, eh? Amesema amevote yes.
Okay.
So tuende, okay. Senator Kindiki Kithure, Tharaka Nithi County. Senator Kangata Irungo, Murang'a County. Senator Lelegwe Tumbesi, Samburu County.
Mr. Speaker, I vote yes. I vote no. Sorry. I vote no. Mr. Speaker, have you heard my vote?
Senator Loitip Anwar, Lamu County. Senator Malala Cleophas Wahungu, Kakamega County. Senator Mpayei Philip Salau, Kajiado County. Senator Mutula Kilonzo Jr., Makwiny County.
You said yes and no, so we treat it as a spoiled vote. Okay, order. Senator, this is not Nandi. These are the results of the division. Ayes 29, nays 7, 1 spoiled vote, abstentions 0. The ayes have it. So clerk.
The Political Parties Amendment Bill, National Assembly Bills number 56 of 2021, second reading, a bill for an act of parliament to amend the Political Parties Act and for connected purposes.
Next order.
Order number 9, Committee of the Whole, the Political Parties Amendment Bill, National Assembly Bills number 56 of 2021.
Senate members are now proceeding on a committee of the whole House to consider the amendments on the Political Parties Amendment Bill, National Assembly Bill number 56 of 2021. The bill before the floor of the House has just been read for the second time after members ventilated a bit on the report that was tabled by the Committee on Justice and Legal Affairs on some of the amendments or proposals that were forwarded to them by various groups during the public participation exercise.
Honorable Senators, we are considering the Political
So
Parties
basically,
Bill
the
Amendment
members
Bill,
have just voted
National
that
Assembly
the
Bills number
bill be read
56
for
of
the second
2021.
time.
Clause 2.
With those
I propose the question that clause 2 be
proposing
part
that
of the bill.
or those
Mover.
voting that the bill be read for the second
Senator
time,
Murkomen.
garnering 29 votes, and those against garnering 7 votes. There was one spoiled vote.
There's some amendment.
There is no member that abstained in that particular vote. So for now, what is happening is that the members will be going into a committee of the whole.
Honorable Senators, can we have some order, please? There's an amendment by Senator Murkomen. Yes.
And just clarify, there will be a further amendment, but if this one passes, I think no, we can do with that later.
Wait, you gave me an order paper without. Thank you, Madam Speaker. Madam Speaker, I have an amendment to Clause 2, that the Clause 2 of the bill be amended. In the first part, Madam Speaker, that paragraph A by deleting subparagraph B, If you look at subparagraph B, is the definition of political party to include coalition or political party. The justification for this, Madam Speaker, Madam Chair, is that when you look at the confusion that this creates, is that the Constitution is clear as to what is a political party. A political party is an entity on its own. It cannot include, it can either be a coalition or become a political party. It cannot be a coalition political party. My argument is that this definition defeats the definition of Article 260 of the Constitution of what a political party is. Number two, it creates confusion. And Madam Speaker, that is not what was intended in the Constitution, and therefore this paragraph is unconstitutional. On the other part is the paragraph C of the same clause 2, which inserts paragraph C by deleting the definition of, in that paragraph C, of direct party nomination, indirect party nomination. Again, if you look at just to start with, the use of the language direct and indirect. If you look at the definition given by this act, it says direct party nomination means the process by which a political party through its registered members elects its candidate for an election. But the understanding of what is a direct nomination in Kenya is, Madam Speaker, one being given certificate directly without a process of involving the members of the party. My second argument is that the Constitution itself expects political parties through their own constitution and their regulation to run how they are going to manage their political affairs. This law, these amendments in this particular bill are too prescriptive. In fact, it's constricting the political space. It's micromanaging political parties. It's making it impossible for political parties to carry out a process of internal management independently. If you look at all over the world, there's never been a country that has this level of prescription on management of political parties. And I shall revisit later the provisions that are relating to the role of the registrar of political time. It's enough, Madam Speaker, to say that clause 2, I am proposing that clause 2 be amended as such, and I ask Senator Aaron Cheruiyot to second.
There's no seconding in committee, but the committee is sitting. Yeah, you just debate and give your comments. That's it. Yeah. I propose a question that clause 2 be amended as proposed. I put the question that clause. Oh, you have requests? Senator Alake?
Madam Speaker,
but please,
Madam Chair, Madam Chair,
just be brief to the point.
Absolutely. Madam Chair, I would like to also point out that I sat with political parties as the chair of the Center for Multi-Party Democracy, and I did submit rationale for proposals to be made, which were captured. So perhaps, as the chair will attest to it, that the political parties have themselves interrogated clause 2 and given what they think would work for them. I submit. I do not support, because the political parties have spoken for themselves.
Okay. Now, Senator Cheruiyot? Senator Cheruiyot. Oh, Senator, you have not requested, so it is Cherargei. Senator Cherargei, that is the person who has requested. Yes, now it is there, but it is Cherargei Kwanza. Okay. First, sorry.
Thank you.
Mr. Speaker, Madam Chair, sorry, is that when you look at the definition that they have tried to do on political parties, and the import, and I look at the comments that were made by stakeholders, they agreed that political parties should have a distinct definition and distinct character. Because if you look the way it is being defined at the moment, Madam Speaker, is that even a cooperative organization like Lelcheka somewhere in Nandi can be interpreted to mean a political party, Madam Chair. And therefore, it should have a distinct and independent and a unique characteristics, Madam Speaker. Although they have tried to look at the import of Article 260, Article 91 on how a political party should look like, Madam Chair, this one does not in any way give. And Madam Speaker, if you look even at the definition that has been done across the world of a political party, it is political party that engages in political activities. But looking at the NGOs, non-governmental organizations, looking at the Cattle Association of Narok City County, look at many others, Madam Chair, all these, when you look at it, there is no distinct interpretation of political party. So I think, Madam Speaker, this clause is mischievous because it means if it is a society, it is a cooperative society, it is a group, it is a CBO, it is a company, Madam Speaker, Madam Chair, it can also mean it's a political party. So I wish it was being specific, and therefore when you look, then why would you pass the clause and then reverse to Article 60, 260 and Article 91 on the formation and character of political parties? So, Madam Speaker, I support the amendment by Senator Murkomen.
Yes, and Senator, you can go ahead because it is almost on the same thing. Yes. So you can as well propose your amendment.
So, Madam Speaker, looking at there is that clause 2 of the bill be amended in the proposed definition of the term direct party nominations by deleting the words through its registered members appearing immediately after the word political party. And in B, in the proposed definition of the term indirect party nomination by deleting the word selected from registered members of the political parties and interviews appearing immediately after the words, and by deleting the proposed new definition of the statement of ideology. So, Madam Speaker, you will be saying all political parties should have an ideology. I don't know what that word means. Senator Barreno has been director of elections in ODM. Therefore, when you look at coalition, a political party, the distinct that has been provided for, Madam Speaker, when you look at, I'm proposing this deletion, is that the political parties must be given a unique
Senator, there is a slight confusion. Okay. So just stick to Senator Murkomen's amendment.
Then I support Senator Murkomen's amendment.
Okay.
And then when mine comes, I will speak to it.
Yes. Senator Sakaja? Senator Sakaja is not in, so I put the question. Oh, Senator Cheruiyot, yes.
Madam Speaker, you know, I'm wondering what is the problem with my card today. When I make requests, it is there, or I would have sacked somebody, but now you have saved someone's job. Anyway, Madam Speaker, I support this amendment because, and I wish the promoters of this bill will be gracious enough to listen to good sense, because basically we are trying to assist you so that your bill actually can pass through the rigorous test of what is constitutional and what isn't in our country. Unfortunately, Madam Speaker, what we have come to know from experience is that on many occasions, when you have such bills where the executive is spearheading and championing similar bills, and they are passed in the manner such as the circumstances that this House is about to do, then good sense take backseat, and it becomes about numbers alone. Article 91, Madam Speaker, of our Constitution is very clear, reading from A to H, and even in subsection 2, about what is a political party and what is not a political party. And it goes to great length describing what determines, what passes the test of what a political party should do, especially subsection 2, about what are the bases, what is the basis upon which you cannot found a political party, where it includes things like a region, for example, where you are saying, and this is so common, I've seen some people who are pretenders to the throne, pretending to be running for the president. Actually, you know, this is a season for brokers. And you find somebody proudly says, oh, this is a party for Mount Kenya, this is a party for the coast, this is a party for the northerners, or for Western Kenya. Madam Speaker, they need to read Article 91, subsection 2,
You cannot found a political party even on the basis of region alone. Part of what is described actually as falling afoul of constitutional provisions on what a political party is include even issues that other people may consider to be so mundane as even a linguistic background alone. Where, for example, someone can say, oh, we the speakers of a particular ethnic tribe, we want to found our own political party. The Constitution, for good reason, prescribes against and says on such a basis you cannot set up a political party. And it goes to great length to describe these particular things, Mr. Speaker. Therefore, when you have such a provision as clause 2 on this particular bill, Mr. Speaker, where you're being told that anyone that has anything that looks like a political party ceases now to have the distinct values and the things that set them up as an individual political party, that you collapse it and you refer to it as a coalition political party. Mr. Speaker, that quickly falls afoul of the law. I wish we would have kept with what is a general practice in the Republic, which is people are generally allowed to form coalition pre-election and post-election. You know, Mr. Speaker, unfortunately, you know, the challenge is that people are trying to legislate good manners and things like trust. Those ones cannot be legislated. If you are a criminal, if you are a swindler, if you should change your political partners, no amount of law will protect you from doing it. And that is a challenge that you are trying to circumvent by passing this particular law and, you know, giving comfort to certain people that, you know, now you'll be part of a big conglomerate. You know, even in the world of business, Madam Speaker, when entities are run under a group, you know, such that, oh, you say this group of companies has interest in, say, real estate and fast-moving consumer goods, they retain their independence. They still have their own mini-boards that run them. Mr. Speaker, Madam Speaker, it is on that basis that I plead with our colleagues that if you really love this bill and you think that it means well for you, listen to good sense, delete this particular clause and word it in the manner in which Senator Cherargei actually will be proposing in his next amendment, which provides, yes, for coalition political parties, but each of them still retain their distinctness, Madam Speaker. Therefore, with those many remarks, Madam Speaker, I support this amendment.
I put the question that clause 2 be amended as proposed, division at the end. Senator Cherargei, please on further amendment to that clause.
Madam Chair.
And I would request that we be brief to the point, yes.
Madam Chair, that clause 2 of the bill be amended. A, the proposed definition of the term direct party nominations by deleting the words through its registered members appearing immediately after the word political party. In the proposed definition, part B of the term indirect party nominations by deleting the words selected from registered members of the political parties and interviews appearing immediately after the words, and by deleting the proposed new definition of the term statement of ideology. I think two things that I want to say, Madam Chair, is political parties should be given opportunity to decide on form and formation, on how they can nominate, on how they can run their political parties. We don't want political parties to be managed, Madam Speaker, and I've said this before, that when you look at the import of Article 91 and Article 260, the mushrooming of many political parties that do not even meet the threshold of Article 91 should not be allowed. And therefore, I think this one is trying to stifle or micromanage political parties. They should allow to do their bit. Secondly and finally, Madam Speaker, is on the statement of ideology. You know, this removal of definition, Madam Speaker, in its essence, is that you are just saying Kisii Tea Farmers Cooperative Society or a CBO or a society or a company, with the import of the definition that has been given in this amendment, Madam Speaker, or Madam Chair, will in its proposed form would proceed and become a political party. But when you look at the jurisdictions other across the world, Madam Speaker, the definition of political parties have been defined, and the underlying factor is that they do what we call political activities. But when you look at this proposed, I don't think, Madam Speaker, it should be allowed because it will be reversing, or because the powers that has been given under Article 91 of the Constitution of Kenya is Parliament was supposed to legislate. And some of these issues that we are raising on this amendment, I'm raising, Madam Speaker, is to put in place and ensure that the definition of political party should be defined properly, so that even if you go to court, an NGO cannot come up and say they want to be a political party. So, Madam Speaker, I propose.
Honourable Senators, I propose the question that clause 2 be amended as proposed. Senator Nderitu for comments. He's out. I put the question that clause 2 be amended as proposed. So, Senator Aaron Cheriot.
Madam Speaker, I continue to plead. Senator Cherargei is granting a second opportunity to the promoters of this bill. And you know it's unfortunate because they are not in this house. I wish they were. If they were here, they would have listened to what Senator Cherargei is kindly requesting them to do. Because if you're a believer of a political party, and I'm surprised, I didn't get a time to read through the presentation from Center of Multi-Party Democracy. If I had a chance, actually, and it's good because I think their president is here.
Sorry, Senator Parano, you have an intervention?
What is out of order?
Give her the mic.
I had initially, Madam Speaker, wanted to oppose the amendment proposed by Senator Cherargei. So I pressed, and you didn't see that I had pressed. So I'll
the time will come for the division, yes.
You know, Madam Speaker, it will be nice to hear from Senator Pareno, because I know she's a deep state in certain political parties. Anybody who has been director of elections knows a lot about political parties and their distinct habits and practices. You know, part of the practices that Senator Cherargei, you are referring. I sympathize, for example, with my good friend, Senator Wambua. I know how Wiper, the party that he belongs to, conducts their nominations vis-a-vis how parties like ODM does theirs. But this time they will be held by the same standard. It will be extremely difficult because I know the kind of practices that goes about in that particular political party. Because, you know, in many years ago, we were members of that particular political party. That's the point that Senator Cherargei is trying to bring, that there's distinct habits, characteristics, practices that are only unique to one particular political party, which unfortunately you get to lose if you're amalgamated into one political party as is being proposed under this coalition political party arrangement, Madam Speaker. Therefore, listen to good sense. And I requested...
intervention by Senator Wambua.
Okay, sir.
Thank you, Madam Chair. Madam Chair, you know, Senator Cheruyot has mentioned Wiper Party in relation to nominations. I just want clarity from him that he is saying that, Cherargei, I am addressing Senator Cheruyot through the chair. I want clarity from Senator Cheruyot that actually what he's telling this House and this country is that Wiper Democratic Movement as the best way of conducting nominations to the other parties that he's mentioning, and that by passing this law, then there is a possibility that our best standards or our best practice would be watered down to the level of those parties that he's talking about.
Senator Cheruyot, please conclude.
You know, Madam Speaker, for example, I come from Kericho. Senator Outa is my good neighbor and friend. The last time he was announced as a winner of ODM nomination certificate, it was not done at Kisumu County Hall. It was done inside the sugar plantation of Moroni.
Senator Ruto, if you have to say something, please put intervention. Intervention.
Okay.
Yes, Senator Ruto.
Chair, you've heard my good neighbor, Senator Cheruiyot, is trying to drag a nomination which was conducted free and fair in Kisumu in the last general election, and saying that we did that in somewhere called a sugar plantation. I want him to be able to table the evidence before this House so that the world should know that the election in Kisumu was not free and fair. And I want to tell you, that was the best in the Republic of Kenya.
Senator Pareno?
Yeah, Senator Wambua, you have every reason to be worried. Because
Senator,
Madam Chair, you know when Senator Cheruiyot talks about the last general election and issuance of certificates, then he directly is trying to impute on my conduct on that particular time, because I was the chair of the election board and I was the one issuing the certificate. And I want to confirm that the Senator Outa is properly before this House, having been given a certificate after winning and in broad daylight. So it was never in a plantation. So you're out of order.
Senator Cheruiyot, please conclude.
I'm afraid for my friend Senator Wambua, because what ODM considers to be free and fair, by the standards of Wiper, that is mass violence. But by ODM standards, you know, that is okay. If I am given, for example, at the next sitting to provide evidence, I know, because I know the gentleman who was a county returning officer for Kisumu is my friend. Madam Speaker, you know very well that at least once every week, for the 53 weeks that are in a year, I am in Kisumu. So I've got many good friends. The gentleman who was the returning officer is somebody well known to me. And I know that where he had to make his announcements and how powerful one
Senator,
can be at that particular time.
Can we confine
I will confine, Madam Speaker, but
the comments
you know, Madam Speaker, I was
to the issue that is before us.
Yes,
please, yeah.
Actually, this is the issue that is before us. That political parties will be forced, because of this, the wording of this particular clause 2, to adhere to certain standards which are alien to certain political parties. And it will be a forced marriage of circumstances that people will be shocked later on. And you are trying to give them an opportunity to understand that actually, even if you wanted to be in a coalition, you can still be in a political coalition without being forced to collapse your party and work under one coalition political party. That's the challenge that I'm trying to explain. And that is what Senator Cherargei is advising us. That as good senators, let us pass good laws that understand actually the distinct practices of our various political parties, Madam Speaker. Therefore, if they choose, and if my colleagues who are supporting this particular legislation think that it makes good sense for them to proceed and do this proposal despite our warning, then so be it, Madam Speaker, because we have warned them, we have given good reasons. Finally, Madam Speaker, as I conclude, there's a point that I made, and I said I needed to hear what the president of CMD, the good senator, my good friend Senator Abshiro, will say about this, because I thought CMD, in its formation, advocates for the growth of multi-party democracy in our country, especially remembering our history, because if you look back to 1992, Madam Speaker, it was a big thing, the repealing of Clause 2A, where all Kenyans were being forced to be under one political formation. That at that particular point, if you are kicked actually out of a political party, you actually lose your seat in parliament. The majority leader, and unfortunately is not here, was once a victim in 1998, where when he lost favor with the powers that be in Kanu, he was actually kicked in parliament. I'm surprised that in his old age, he could be advocating for such a dangerous and draconian piece of legislation, Madam Speaker. The reason why I mentioned CMD is because Center for Multi-Party Democracy, if you read through their objectives and reason data, they speak about inculcating cultures of democracy and seeing the growth of multi-party democracy in our country. Is this, how does amalgamating 10, 15, 20 political parties into one coalition political party and forcing people to run under one nomination, come to parliament with only one distinction of being under one political party, how does it sit with the practice of multi-party democracy? It's a comment that I'd wish to appreciate and listen to from CMD. Thank you, Madam Speaker.
Senator Murkomen?
Senator interrupted me when I was making my conclusion, but I understand her. She can never understand some of these challenges that we are mentioning. Because when you say you either choose or you don't, a practicing politician understands what a political party means. In certain parts of the country, when you're done with your political party nomination, it's as good as a general election. So it's not as easy as she may want to put it.
Yes, what is in the intervention? Senator Faria.
Madam Speaker, to come into a coalition is a choice of different parties. So if they don't want to be subjected to that rigorous process of joint nomination, they should not join those parties. They can, the law does not prevent individual parties contesting for presidential and other seats. So that is why I was just, because you mentioned me, I just wanted to respond to that. Thank you very much.
Okay, Senator Murkomen. But please let us stick, because there are a lot of interest, let us stick to the point and be brief, please.
Thank you, Madam Chair. I think one of the interventions here by Senator Cherargei that I have not contributed to is, that was not part of my amendment, is this part that deals with, as Senator Cherargei says, that we must delete the proposed new definition of the term statement of ideology. If you see this thing of statement of ideology, which is applied later inside in the bill itself, it says that it sets out the doctrine, ethical ideals, and principles of the party. If you look at the Constitution sets the basic requirements of a political party. And putting in place more stricter requirements for that political party is going beyond the Constitution. The Constitution in Article 91 says every political party, and then lists all those issues of democracy, promote national unity, national in character, respect rights of person, minorities, and so forth. And then says shall not be founded on religion, regional, encourage violence, intimidation, like some parties that do, maintain parliamentary force, engage bribery, and so forth. Madam Chair, this thing of statement of ideology is another roadblock. Statement of ideology will not help us, Madam Speaker, to make political parties more responsive to the members. If you look at what is being defined here, it says statement setting out doctrine, ethical ideals, and principles of the party. All these things, what you would have wanted to be principles or standards or requirements of a political party are already listed in the Constitution, whether Article 10 as the values and principles of the Constitution. What does this do? It only creates one more layer of bureaucracy where the registrar of political party will tell another political party, and this is exactly the objective of these drafters, to wake up and say, oh, we are not registering party XYZ because the government is not comfortable with the ideology, or that the registrar of political party is not satisfied that the ideology of this political party is in consonance with the values and principles that the registrar is trying to follow. Or, Madam Chair, it's also possible that the registrar will just say the ideology of party X is the ideology of party Y. So I support Senator Cherargei's amendment. These superfluous additional provisions on statement of ideology are unnecessary. They are just other bottlenecks insofar as management and running political parties concerned.
Honorable Senators, as I allow you to make comments, let us just mention the rationale of the amendment, why you are supporting it or not supporting it. Yeah, let's not go into the debate. Senator Abshiro.
Thank you, Madam Chair. Madam Chair, I know my friend, the honorable member, Senator of Kericho County had mentioned that the president of CMD is here and should have supported amendment. But what I'm trying to say, as a president or as the chairperson, I have brought specific verbatim proposals from my political parties as provided therein. And what they have said to me with regards to even the clauses that are being requested for amendment, that these are entrenching democracy by making sure that instead of very many fragmented little parties, we are having, in the United States of America, for instance, we have two parties, Democratic Party and the Republican Party. Is the democracy in America strong or not? And in that same respect, consolidating similar ideologies and ensuring that we have strong coalitions is actually an entrenchment of democracy, is actually a maturity and maturing democracy. So we cannot be in 1992 where when the Center for Multi-Party Democracy was conceived. Today is 2022, Madam Chairman, and this is what we're saying. Political parties that have similar ideologies are affinity grouped into one strong party as a coalition, and that can only be an entrenchment, an institutionalization, and a maturing of democracy and nothing less. I do not support. I support what my political parties have given and have brought before this House. I thank you.
Senator Lekina.
Madam Chair, I thank you for giving me a few minutes to comment on this. I rise to object to this proposed further amendments by Senator Cherolgai. Madam Chair, I think there is a confusion in what is a direct nomination or an indirect nomination. A direct nomination simply means that, and the bill actually explained it very, very clearly, it means that it's a form of universal suffrage by the members of a political party. We move on further to the issue of ideology. We move into the issue of ideology. When we move into the issue of ideology, Madam Chair, I think it's about time that this country start moving into and understanding the issues of ideology.
Are you commenting on Senator Cherargei's amendment or Murkomen's amendment?
I'm commenting on Senator Cherargei. I had consulted with the clerks, and they told me that this is what is being discussed now.
Go ahead.
So I'm commenting on it. I'm objecting it because I think Senator Cherargei wants to misguide the public on the definition of ideology, a definition of direct or indirect nominations. Direct nomination is very simple. And I think what this bill seeks to do is that it seeks to bring in disciplines to parties. When you have members who are bona fide members who subscribe to a particular school of thought, those members then ought to be allowed to choose the candidate that they want to represent their ideas. So, Madam Chair, the public ought to know that when the proposals of this bill define the term direct nomination and indirect nomination, direct nomination only means that members of that particular party, and if it is a coalition party, members of the two political parties. Like, for example, if it's Jubilee and ODM, those members of Jubilee and members of ODM will participate in either a direct nomination, where it is universal suffrage, or indirect nomination, where it is through delegates. Madam Speaker, on the issue of ideology, I think it's about time that we try to demystify what this ideology means. I was listening to Senator Murkomen trying to say that
Senator Olekina, please let's not go into the debate.
No, it's not about the debate. I just want to clarify one thing, Madam Chair.
But
kindly allow me to clarify this one. Because when I heard Senator Murkomen saying to the public that that the register of political parties might say that this ideology is similar to the other ones, I think that would encourage them more to come and form into one coalition. And I think it's about time that we look at other democracies. If you look at the US as an example, Madam Chair, and this is my last comment on it, if you look at the Democrats and the Republicans, the Democrats subscribe to a bigger government where the government is in the people's life. But when you look at the Republicans, they are more conservative. They want lesser government in their life. They want to be able to pay less taxes. So I think this is an issue that now, at this age of our democracy in this country, it is important. And that's why I strongly oppose this deletion or this amendment being proposed by my colleagues, because the proposers of the political parties amendment bill saw it fit to try and clarify so that we can now be voting for people based on issues. Thank you, Madam Chair.
Honorable Senators, I'm saying this for the third time. If you are bringing an amendment, just tell us why, tell the House why you are making the amendment. And if you are supporting or not supporting, just give us the rationale. It's as simple as that. Let us not debate at the third committee, please. Yes, Senate.
That you're making, because on third reading is not the debate during the second reading. On the third reading, members can have again another opportunity to make general comments. But during the committee of the whole House, the mover is supposed to justify the House to the committee why that amendment is necessary, and there should be an engagement. Even the members who are contributing, I don't think we are doing the right thing. We should interrogate the mover on specific provisions why you need that amendment. So it's almost a question and answer session. But you know, we are now in debate, which was there during the second reading. During the third reading, in fact, Madam Speaker, I've realized that in this House, people don't use the third reading the way it should be used. Yeah, so you stand guided. Yeah, but now we must be technicians now, so that we interrogate why these amendments are necessary. But I think we are debating again, and that was during the second reading, and I think the clerk can advise. Madam Speaker, I forgot in the old Parliament, Amos Wako used to move so many bills. And as Attorney General, during the third reading, he would be engaged specifically on each and every word and comma and so on, not a general debate.
Honorable Senators, I put the question that clause 2 be amended as proposed, division at the end.
Clauses 3 to 6.
I propose the question that clauses 3 to 6 be part of the bill. I put the question that clauses 3 to 6 be part of the bill, division at the end.
Clause 7.
I propose the question that clause 7 be part of the bill. Mover. Amendment, Senator Wambua. Olekina, you are doing on behalf of Wambua?
Yes.
Okay, go ahead.
Madam Chair, I've been delegated by Senator Wambua, and upon consultation with him and all the other colleagues, Senator Wambua has chosen to withdraw the amendment.
Madam Speaker.
You know, I've not even given you the mic, but anyway, go ahead.
Yeah, thank you. You know, you are my good neighbor. Thank you, Madam Chair. Senator Wambua mentioned to me 2 minutes ago and was trying to convince me to support his amendment, actually. We were seated there. I don't know who called him, but it was something written HESKM. I suspect maybe his party leader or something. So he's behind there in the consultation room. We can give him a minute to come back. He mentioned to me that, that he needs actually my support for his amendment.
You know, there's only one option. If it's not there to move the amendment, we can only drop it.
No. Alternatively, Madam Speaker,
yes,
you can move to the next amendment as a matter of procedure.
It is
then he will formally withdraw. No, that's not the. But there is a procedure. There's a procedure for withdrawing an amendment, Madam Speaker.
The procedure is, if it's not there, we just drop the amendment.
No, Madam Speaker.
Look at the standing order.
Yeah.
What's your point of order, Senator Murkomen?
I totally agree with you, Madam Chair, that as per the standing orders, if the member who is moving the amendment is not here, it is withdrawn. But what we are addressing is the move by Senator Ole Kina purporting to withdraw an amendment on behalf of Senator Wambua, because there is no such a procedure in the standing orders. And I'm saying this because, Madam Chair, the danger out there, the people of Kitui are watching. And this can create two scenarios. One, that Senator Wambua ran away when serious business was coming, or that Senator Wambua, Madam Chair, was coerced to run away, or that Madam Chair, Senator Wambua is being twisted to withdraw an amendment.
No, Senator,
if the right procedure is followed, because
it has always been our practice. I've seen several members move amendments on behalf of others. It has been a practice in this House.
Senator Wambua, Madam Speaker, Madam Chair, is a very honorable man. He could have decided to follow the standing orders by absenting himself for purpose of this thing to be withdrawn honorably. But the voice given by Senator Lekina creates a different impression.
So let us cut the long story short. If, we drop his, we drop, just hold it. We have to drop Senator Olekina's statement and still, yes, because now we can't prove that. No, just wait. And we just drop it out altogether. That's the best that we can do. And we move forward. Let's move forward.
Clause 8.
I propose the question that clause 8 be part of the bill. I put the question that clause 8 be part of the bill. Division at the end.
Clause 9.
I propose the question that clause 9 be part of the bill. Mover, Senator Sherarge.
Thank you, Madam Speaker, Madam Chair. Clause 9, that the bill be amended by deleting clause 8. Clause 9, sorry. When you look at that, section 10 of the Principal Act is amended in subsection 1 by inserting the words or a coalition of party immediately after the words form a coalition. So the input is that you don't need to form a coalition, because under the Elections Act, Madam Speaker, as at now, is that you form a coalition and then you deposit coalition agreement with the political parties. But what he's trying to do here is now using a party that is conglomerate, or how do you say, the party that is amorphous, something that does not, where now you are using a political party or a coalition of political party, instead of political parties coming together to sign a coalition agreement. So what they are trying to do now is use coalition of political parties. If, for example, there is a party called Kuzimia Coalition Party of Kenya, is that Kuzimia Coalition Party of Kenya comes together and say this Kuzimia Coalition Political Party of Kenya. And then the next part there says, provided that in a case of coalition political party, the coalition political party shall submit coalition agreement at least 120 days before a general election. What the import is that under the Elections Act as it is now, Madam Chair, is that there is pre- and post-coalition agreements that are deposited with registered political parties. The fact that you want to force, they are forcing, in my culture, because we take care of cows, you don't force cows to drink water. There is a saying that says that. So inside, you are trying to force that if there is a coalition of political parties or form a coalition, it must be done within 4 months. And therefore, I'm proposing that this clause be deleted, clause 9 be deleted, Madam Speaker, and remain as it is under the Principal Act. I thank you, Madam Speaker. That's my justification.
Yes, further comments by Senator Murkomen. Senator, just 1 minute first. Let me propose. I propose the question that clause 9 be deleted. Senator Murkomen.
Thank you, Madam Chair. Madam Chair, Senator Cherge is making a very important point here, which is that there is this creation of a coalition political party, which I had already proposed its definition be removed in the definition of political party because I don't think it's a political party. But at this section, what we must keep our eye on is the issue of forcing this coalition political party to submit the coalition agreement at least 120 days, which is basically 4 months before the general election, which creates a contradiction with the timelines required for coalition agreement, which is 3 months. Again, Madam Chair, this period of time is a bit long. I want to help our friends because we are not the ones who intend to apply this section. This is the reason why our friends on the minority side would really want to have this thing and put it in place in 4 months, which is barely April before the elections. Just want to help them to tell them that this is too early. By that time, you may not be ready. Ordinarily, I think, Madam Chair, if a Kenyan would challenge...
Senator, now there you are
challenge,
you're surpassing.
A little bit, but not so much. If a Kenyan was to challenge this constitutionality of timeline for coalition agreements, Madam Chair, I think they would succeed. And they would succeed for 2 reasons. One, the constitutionally, political parties should be able to come together anytime. In parliamentary system of government, coalition arrangements can happen one morning, the afternoon, the Prime Minister is removed. In our situation, we have constricted, there's a period of time, which is now, in the case of coalition political party, or whatever is called coalition political party, is supposed to be 4 months. And for the other coalition agreement in the Parent Act from the 2011 when it was passed, it is 3 months. I really think that this time is unnecessary. Political parties should be, at any given time, be able to come together and form a coalition, pre or post. If government of the day feels like they are now weaker in parliament, they can rob in another party, form a coalition. In the situation like our friend, the president, struggled to do the same, but unfortunately in the majority side, he had only 10% of the support from the majority side. Now so it's an example. It's alive. This bill, Senator Orengo, is not an abstract. Yeah, so I'm seeing you very agitated, but this bill is not an abstract. This bill is a culmination of handshake, okay? And, you know, it is, this marriage is supposed to be consummated. Senator,
can you stick to the amendments?
Yes, that's what I'm saying.
Yes.
For this locking, Madam Chair, political parties away from forming coalition, political party, or coalition, including even the Parent Act, I still think it's unconstitutional. And therefore, the wisdom that comes with this bill and Senator Cherargei's proposal is that this 120 days is unnecessary.
Senator Aaron Cheruiyot.
Mike, please. Yeah, thank you, Madam Speaker, Madam Chair. For the umpteenth time, I'll repeat to my colleagues, please listen to good reason. It will help these law viewers in the fate that awaits it in the courts. I'll give you a very clear example. What Senator Cherargei is trying to assist you, and even, I don't know if Senator Cherargei is aware of this. Senator Judy Pareno, you have run political parties. You know that about a year to elections, IBC publishes regulations that will govern, and timelines actually, that will govern the forthcoming general elections. In this current election of 2022, political parties were supposed to submit at least 4 months before the day of nomination their nomination rules. So virtually all political parties have already submitted their nomination rules. All the major, any political party that intends to, for purposes of nomination exercise, which IBC has further published that by 22nd of April this year, IEBC expects every political party in the country to have actually conducted its nominations. Yet, 4 months behind, as per IEBC regulations, you should already have submitted your nomination regulations. As we speak today, today is the what's the date today? 26th. Today is the 26th actually of January. meaning that you hardly have 2 months plus to the nomination deadline. If you pass this law and convert yourself to a political party, either you'll call it Azimio or whatever it is, already you are afoul of that particular regulation. Because by the time you'll be formed into a coalition political party, where's the 4 months that you need so that you submit your regulations? In fact, you will have to apply to IBC to selectively make rules for you as an individual party to allow you submit your regulation rules. And on that basis alone, part of these clauses will actually lead to this law being annulled by the courts. Therefore, Madam Speaker, I hope our colleagues can listen to this and perhaps agree with Senator Cherargei, because this makes a good proposal that individually you can remain as a party, but not a coalition political party. Otherwise, many of us will be waiting to see how IBC will treat this particular coalition political party. If they are allowed to submit nomination rules outside of the regulation time, then many other political parties will be requesting for IBC to vary as many things as possible, as opposed. That's why in their submissions, if you read through the submissions of IBC, they raised a valid concern about this particular clause, because they're saying you are now forming a political party while you are way deep into the electoral cycle, and there are things that political parties should already have done by that particular time, Madam Speaker. So I don't know. That presents a challenge. Therefore, it is for that good reason that I support what Senator Cherargei is proposing. Thank you, Madam Speaker. Madam Chair.
I put the question that clause 9 be deleted, division at the end.
Clause 10.
I propose the question that clause 10 be part of the bill. I put the question that clause 10 be part of the bill, division at the end.
Clause 11.
I propose the question that clause 11 be part of the bill. Mover, Senator Murkomen.
Madam Chair, if there is no other clause that colleagues here should support, I beg them to support amendment of clause 11 for 2 reasons. One, it doesn't fall within your political contests out there, which is about the debate that has been going on in the country about what Parliament wants or who wants where to form a political party or a coalition and so forth. Clause 11, and I really hope this clause 11 emanated from our experience or my experience representing Senator Maura. Madam Chair, and I have to give the explanation of a proposed section, new section 14A, and I've said we delete the 4 and substitute with the following, which says, upon notification under subsection 3, and this is the procedure I'd like us to follow, the registrar shall, where the registrar is satisfied that the political party has complied with the procedure under subsection 2, notify the member of receipt of notification of the member's resignation from the political party on part 1. So when the political party deems a member to have resigned from the party, that notice is sent to registrar for purpose of removal of that member from the political party because he's deemed to have resigned from the party. So up to there, we notify the registrar. But the other additional provision I've added there that I want us to really interrogate is the part that says the registrar shall, upon issuing the notification to the member under subsection 4, publish by notice in the Gazette the registrar's intention to remove, upon the expiry of 21 days after publication of the notice, the member's name from the register of the political party. This is the explanation, Madam Chair. At the moment, because of the absence of this type of law, a political party will put together, like Jubilee did in the Maura situation, a disciplinary panel under its own constitution. Then they quickly move that disciplinary process, expel the member at about 5 p.m., okay, or 4 p.m., or even 3 p.m., send to the registrar immediately because the registrar is compliant to that political party. She receives the notice for expulsion of the member, and the government printer is on standby with already prepared gazette notice for removal of the member. So that member, his name moves from the party, it goes to registrar that night signs and sends to the government printer. By midnight, the member is removed from the party. Then you wake up in the morning trying to run to court to get court orders to stop the implementation of that gazette. By the time you are even filing the matter, the Speaker of the House has announced that so-and-so's job is gone. So what happened in Mwaura case? It was exactly that. What only saved us is that the process of replacing him took a little longer time. He did not reach the Speaker, and we got the orders in the middle. Now, what is the proposal here? Let the registrar political party receive the notice from the party and send it to the member and telling the member, you have received notice that you have been expelled from your party or deemed to have resigned from your party. Take notice that upon expiry of 21 days, you will cease to be a member of that party, and therefore the expulsion takes effect. What does that do? Gives the member the opportunity to exhaust the legal procedures that are existing in the party, either by going to the political parties tribunal or going to high court. 21 days are good enough. Even 21 days he has not got the remedy he requires, then the expulsion takes effect and the Speaker can tell. Why am I saying this? We shouldn't be in a hurry to remove someone from a political party. We shouldn't be in a hurry to remove an elected leader from his position in parliament. There are other ways a party can discipline its members. They can deny him opportunity in some committees. They can do all these other things. They can even deny certificate later and so forth. But to remove a popularly elected leader in such a cavalier manner and in a manner that is so expedited, I think is unfair. And therefore, I'm requesting my colleagues to accept this. If you read that, I only read part 14A. For 14B, 14A is for situations where the party deems the member to have resigned from the party. And deeming a member to have left the party has many ways. They have said supporting ideology of another party, supporting formation of another political party, and so forth and so forth. If you look at part B, it talks about expulsion of a member from the political party. Again, a similar procedure. Let the party hold its own internal inquiry, send the letter, Mr. Speaker, and then now let the process. I have experience on this matter, and I have almost clear in my mind that even in the next parliament, one of us here might face the same procedure. Just like Aisha Juma faced, just like the late Dory faced, and I represented him as well. God is rest his soul in peace. And now Senator Mwaura has faced. I am begging members, because this section 11 I'm introducing, this clause 11 I'm amending, has nothing to do with your other debates there. It's just giving members fair hearing, fair processes, opportunity to exhaust existing legal mechanisms, including court processes, so that then after those 21 days, if he didn't get the remedy he requires, or he doesn't have an order, an injunction, and he did not succeed in court, and the party has the capacity to deal with it in court, then it can now be removed from the party. But what is happening at the moment, where people are being removed at the speed of light, especially because the government of the day is in control of the procedure, this is dangerous. And Mr. Speaker, the government of the day tomorrow might be Murkomen. Murkomen is a fair man, but it can be someone else. That, Madam Speaker, will do the same to a colleague here who is in their party or whom we are together in the same party and we have disagreed. Let's do law for posterity, and this provision is useful for county assemblies. So many, if a lawyer who is here, Senator Orengo, all these senators who are in legal practice. Madam Speaker, I don't think there is a senator here who is in legal practice, including Mutula, who has been here and so forth, who has never received a case from county assembly or national assembly or the Senate of party trying to expel somebody from their political party, and you are running around to get orders in time before they gazette that expulsion. I think this is a fair provision, Madam Speaker.
I propose the question that clause 11 be amended as proposed. Senator Aaron Cheriot, please just be direct to the point.
Thank you, Madam Speaker. I've listened to Senator Murkomen. There's something still constitutional about it, and I wish the promoters of this bill would listen to good reasoning. And I'm sure if actually they listened to your advice, Senator Orengo, they wouldn't have this provision. Because, Madam Speaker, what Senator Murkomen is proposing actually gives strength, because to Article 103 of our Constitution, subsection 3E, actually subsection 3, that Parliament shall enact legislation providing for circumstances under which a member of political party shall be deemed for purposes of clause 1E to have resigned from a political party. Speaks about resignation only. It's not even about this business of expulsion. So it leaves me wondering, even as we debate about what his pride that us as an institution, please reward so that you give additional time. I'd wish him to clarify, because that's the purpose of third reading. And that's the purpose of this particular stage when you do amendments, that you issue clarifications, and those of us that are not clear about it. Is it for resignation purposes or for expulsion? Because if it's for expulsion, as my reading of this particular wording of this clause is, then it is completely out of the law, because nowhere in our Constitution does it speak about the expulsion of a member of Parliament. It's about resignation and providing circumstances under which a member is deemed to have resigned, but not about expulsion, Madam Speaker. Therefore, Madam Senator Murkomen needs to, first of all, give us that clarification. Then perhaps if that is clearer for me, I can make up my mind whether to support him or not support. That's the purpose of this.
Yes, Senator Murkomen.
If Senator Cheriot cared to listen, and not to be distracted by Senator Ngugi, who is not facing elections, yeah, Madam Chair. If he cared to listen, if he cared to listen, I didn't know Ngugi was still here. But your consultation...
What is your intervention, Senator Ngugi?
Madam Chair, you know, we'll know whether anyone is vying for any position, even the civil servants on 9th of February. And I didn't know that nowadays Senator for Elgeyo Marakwet is a commissioner in IBC.
I thought you are on...
No. You see, he used very wrong words. He said, if I care to listen. How do we help such men, Madam Speaker? It is his amendment you are trying to clean up. Then he's using not very friendly language on us. If he does not withdraw that, Madam Speaker, I will drop my support for this amendment.
Madam Speaker, he can, I want Senator Cheriot to listen very carefully. He can withdraw his support for this bill, but we can come and use it against him, Madam Speaker, in another few months. The point I'm trying to make is that if Senator Cheriot cared to listen to my earlier presentation, which you, Madam Chair, you followed so keenly. You followed so keenly. I was watching you. That already the Act itself has provisions on expulsion of members. Yeah, expelling a member from a political party. That's the one that was used against Maura, Aisha Jumwa, attempted against Aisha Jumwa, Dori, and all other members. Or so survived at the Court of Appeal, you know. So if you listen to what I said, the current existing provision on expulsion, we need to provide a mechanism that allows a member to have time to take legal, to seek for legal remedies in a court of law, insofar as expulsion is concerned. And then now, because this bill was giving also a similar provision on when a member is deemed to have resigned from the party, and that deeming to have resigned is emanating from the Constitution. So this is the structure of how to operationalize it. I also said, in the same way, let's give, after the registrar has received that notification from the party saying, so-and-so has been deemed to have resigned from the party because he's promoting another party or the ideologies of another party or, Madam Speaker, formation of another party, let that member, let the registrar gazette the deeming, which is like a removal or expulsion, then the member be given 21 days to now wait for his fate. And if he decides not to take legal action, after 21 days, he ceases to be in that party. If he goes to court and he gets interim orders and then eventually succeeds in court, so be it. If he doesn't succeed, he's also expelled. That's the point I'm trying to make. And this is, of all the amendments which are here, I am sure nobody has been given any instructions by their political party against it because it's new and it's useful for all of us.
Senator Cheriot, can you conclude?
Yeah, you know, it is my job to also make. Now it is clear. No, but it's still not clear what. I don't think he equally cared to listen, though I want to use better English than what he's supporting. You know, Madam Speaker, what I was speaking to, my reading of 103, Article 103, subsection 3, about the legislation that we are enacting for purposes of somebody being considered to have resigned. He has now clarified about the specifications. And he's made it clear that it is about the process for him. That is what matters at the end of the day, so that you don't have a situation as what he has briefly described. And I really wanted to hear the comments of a senator for West Pokot County. Because previously, under the old constitution, something similar to this has been applied to him. That on one fine morning in 1988, he said something that KANU, the then ruling political party, found to have been offensive against the party leader and the party, and they removed him actually within an instant of being a member of parliament. In fact, he once said that I think he had walked out of parliament to do something, and when he came back, the sergeant at arms could not allow him back to the precincts of parliament. Why? Because he had lost his membership of this house. How such a man, 30 years later, comes to support this legislation with all the uncertainty about it, without giving life to the process that Senator Murkomen is describing, baffles me. And it's something that I'd wish to request that as colleagues, even if you love your party leader, even if you love your political party, this is not legislation that you pass. I cannot pass this legislation, even if I'm sure that my own father is a party leader of the party that I belong to. Because why would you want to make it easier for somebody if you disagree politically, and you know the things that make some of these party leaders of ours angry, you make it easier for them to kick you out of political parties. Yet it is the Constitution actually gave us powers as legislators that go and legislate how you can be removed for parliament. Then we come and make it so easy for them to kick us out. Surely have we lost our minds? We need to be clear about this, Madam Speaker, and listen to the proposal that is being given unto us, that we are being told, at least let us then set out a process, give it timeline, so that you are able to be given time to prepare yourself, prepare a response. You know, my good friend, Senator Justice Stewart Mazzai, you're a believer in the rule of law. You believe in justice. Please allow this provision to be amended as is being proposed by Senator Murkomen. What is so difficult in giving a political party whatever time that we have mentioned, be it even 6 or 7 days, as he's proposing, then you present yourself, make a case, at least you are able to, even within the mitigating, the intervening time, you are able to push for mitigation of whatever they are proposing in certain quarters. Otherwise, if we make it immediate, and you know how when they want to kick you out of parliament, it works like clockwork. We've sat here on certain occasions when we've handled the impeachment of governors, and by the time we are walking out to the parking, the Gazette notice is already out. That is what is going to happen to us. Yet we want to give them this legislation. Surely, colleagues, it's not fair. I plead with you that listen to this proposal. For that good reason, Madam Speaker, I support this amendment.
Yes, Senator, Minority Leader.
Mr. Speaker, I just wanted some clarity in the from the chair, although there is already precedent on how to deal with special sittings. The Gazette notice that was issued by the Speaker on the 19th January 2022 directed that the special sitting on Tuesday and Wednesday and 26th shall commence sittings at 2:30. Now, what is significant in this Gazette notice, it did not state the period for that special sitting, so that when the special sitting is within the day, the special sitting can go on until midnight. Yeah, in fact, that has happened before. And this was very deliberate on the part of the Speaker. So I think we should have some clarity that this special sitting commences at 2:30, but it goes on so long as we don't go to 1 minute past midnight of 27th day of January, because on the 27th day, the special sitting starts at 10. So again, the Gazette notice is quite clear. Because otherwise, where the standing order states that we should sit from 2:30 to 6:30, a motion would have been necessary to extend the sitting until whatever time. But I just wanted that clarity because it has been a practice that where the time of ending the sitting is not stated, so long as it is within the day, you don't need to rise on a point of order to extend the time. Because you're extending it from wartime to wartime. Because, you know, it would have extended time if it stated that the time ends at 6:30. Equally, the Speaker knows that sittings normally start at 2:30 in the afternoon. So he need not have stated it. Or he could have said 2:30 to 6:30. So I just need direction, because there's been practice on this in both houses, and it's not really a matter for debate, because the Gazette notice speaks for itself.
Yeah, we are not going to debate on that. I will give a way forward on that shortly. Further clarity? Senator Murkomen.
Madam Chair, on matters of extension of time, in your clarification, the first thing is to ask whether a chair of a committee can give directions on the matters of time at the committee stage while chairing a committee. Number two, precedent, which has been there even before when we have had a special sitting, particularly at the time we were considering division of revenue bill, we had to extend time. One had to come with a motion to extend time. And even then, the Gazette did not say 2:30 to 6:30. And the last thing is yesterday, what happened yesterday? Thank you, Madam Chair.
Yesterday there was no business, and today, just why I said I'm giving a direction on that shortly. So let me put the question. Oh, Senator Sherargei. But kindly let us be brief and to the point. Just tell the sitting why you are supporting or not supporting the amendment, please.
Madam Speaker, I think we are here up to midnight, so time should not be an issue. Madam Speaker, when you see
it's not a matter of time, but we need to be seen to be moving forward.
Okay. Madam Speaker, in a reason to enrich the proposed law, in any principles of natural justice, there must seem to be justice, and justice ought to be done at any given time. The proposal of introduction of section, and I know most of colleagues who are nominated, especially on the side where I come from, Madam Speaker, the Jubilee, for the last 2 or 3 years, they have been living under morbid fear, because somebody wakes up in the morning and decides to remove you from the party list, the registrar political parties degazettes you, and before you know it, Madam Speaker, it will be contravening principles of natural justice. So I think the introduction of 21 days is very important, because it will give proper timelines, so that you don't wake up one morning and you are not a member of parliament or a senator or a member of county assembly or any other elective position, Madam Speaker. So, Madam Chair, I think the process, what Senator Kipchumba Murkomen is trying to do is just to to ensure that the principles of natural justice and its principalities, and you know, he taught me as my lecturer in law school in Moi University, is trying to be meticulous and ensure that when you are being removed, and the only caveat some of us had, the elected senators, is because we could not be removed. But the nominated senators, in fact, I can confess that even the people like late Senator Prengei were being told, vote out Senator Professor Kindiki, so that you will not be removed from Jubilee Party. So, Madam Speaker, I think it is very important that even if, and you know, Madam Speaker, you know, these parties in Kenya sometimes belong to particular individuals who have interest. Today, if you vote against a position of a party, because of your conscience or you believe that is something, and your party leader believes, Madam Speaker, that you defied him or her, Madam Speaker, you can lose your position. And secondly and finally is the freedom of association and engagement. Madam Speaker, you can imagine if I come to your county and conduct an Arambe, you are an ODM, an UDM member, and somebody somewhere thinks that you are promoting ideologies of another political party. So to oppose this section, I support Madam Chair.
Senator, my minority leader.
Madam Speaker, Madam Chair, I oppose the amendment. The reason why I oppose the amendment, and the mover has not been clear on this issue. First of all, there was a certificate accompanying the bill that it was not taking away the rights under the Bill of Rights, that the Bill of Rights have not been touched. Now, if you look at the clause, it requires that notification should be given to the member. Second, the member must afford the member a fair opportunity. It is there. Now, if you read this particular bill, because the law should be read holistically. You don't just read one section and then assume that that section would help you understand the bill properly. But what I wanted to say, since the Bill of Rights has not been negated by this bill, the governing legislation then would be Article 47, which guarantees that if any institution of government is making an adverse decision, you should be informed and know the reasons. And then there's the Fair Administrative Action Act. And Madam Speaker, I just wanted to tell you, inform the committee that if you look at Section 4 of that act, and this is why Senator Manyora succeeded, the requirements under the Fair Administrative Action Act are so onerous. You must be given notice, you must be given a fair hearing, you must be given opportunity to cross-examine, and the right to review to go to the Court of Appeal, and it has not negated. When we were speaking, I was not rising. I was not. Why are you agitated? I'm just. Yeah.
Just let him conclude. I'll give you. Oh, okay.
I want Senator Orengo to relax, not to be, because point of orders are allowed by the standing orders, and particularly when he becomes the governor of Siaya, to say the bill does not allow a member to go through all the motions. Again, Senator Orengo is misinterpreting or misleading the public as to what I said. What I said is that when the process has all been completed and sent to the registrar of the political parties, there is nothing that intervenes between the decision by the, and Senator Orengo, please, and I'm sure you are sharp enough to appreciate what I'm saying. Between the period that the party makes the decision, the gazettement by the registrar, and the removal of the member from the chambers, there is no law that is intervening. And I even gave the example of Senator Manyora. You are removed at 4. The party has gone through all its disciplinary process. But at 4 p.m., makes the decision and then sends to the registrar, who seems to have been sitting on her desk. By 4:10, the registrar has issued a gazette for removal of the member. By 4:30, that gazetteman is already with the government printer. By 5 p.m., the person has been expelled from the party and loses their position. That is what I'm talking about. It's not the process of being heard by the party. They have done the disciplinary. In any case, you know that in the case of Maura, disciplinary was done and there was enough time within the party. He was even heard. He was represented. But the problem occurs between after that and his ability to go and seek legal intervention, because then the gazette notice just comes immediately and the person gets expelled. In fact, he was lucky that the replacement did not come as fast, because if the replacement had come as fast, he would be gone. So what that amendment seeks, Senator Orengo, Senator Ledama, don't distract Senator Orengo. This is a very serious matter, especially for someone who becomes governor. It's a very serious matter. The problem we are dealing with here is that if Senator Mwaura had been expelled from Jubilee at 9 in the morning, a decision issued 9 in the morning, it would have been possible for the decision to be gazetted at 10 and Mwaura be announced by the speaker by here at 2:30, removed, and for Jubilee to send his replacement, which was supposed to be Senator Leshore, by 4, and the speaker to come back here and make another communication at 6. And Senator Mwaura, even if he goes to High Court, Court of Appeal, to reverse that decision, it would have been impossible. What we are saying is that between the period you are being gazetted for expulsion, let the gazette notice come out saying, so-and-so has been expelled from Jubilee, but it will take effect 21 days from the day of this gazette. That's all, Senator Orengo.
Let him conclude.
Madam Speaker, Madam Chair, even for purposes of election petitions against members,
Honourable Senator, I would like to interrupt a little bit.
Yes, yes.
And to give a direction that the sitting was, when we were given the notice for this sitting, it was from 2:30. And it was not given the limit, not to 6:30 or whatever time. So we are going to sit today until we finish this matter. We are following precedents, and that is not the first time that is being done. So, Senator, you can continue.
Now, I've seen this in election petitions. In fact, one of the cases, Senator Wetangula, where in fact there was an order for his removal from this house, which came to the Speaker. Now, the Election Petitions Act, once you have been, your election is nullified, then it is for you really to take the action. It's for you to take the action. If you're indolent, then that right will lapse. So my position really is that once you got constitutional protection, and once you are not indolent, like Senator Mwaura was not indolent, and ran to court and got stay orders, I'm sure that any member who is affected by a decision of the political party's registrar and who is conscious of his rights, I am sure that that gazette notice the Assembly or the Senate before an action is taken. And more importantly, the constitutional protection that even where there's a threat, under Article 22, 23 of the Constitution, you don't need to wait until you are removed. Article 23 and 23 of the Constitution, even on a mere threat. But what I'm saying is this, at the end of the day, it is Senator Murkomen whom we should be interrogating, and he gives clarifications. The amendment is not mine. Yeah, so instead of waiting for us seeking clarification, you're giving us a lecture, and Senator Cheriot is giving us another lecture. So in a way, you should give us, I mean, how are you going to persuade us? Yeah. Then during the committee stage, give the members, because they have read this, they have had notice of the amendments that you have. and this is not really a debate on the bill, is on the specific amendments that you're trying to bring. So we seek clarification from you, and in fact, there should be a question and answer. But if you are lecturing us, then we can just listen.
Senator Olekina, clarification?
Yes. I'm not the chair, but I would assume so. I would assume so. Madam Chair, I'd like Senator Murkomen to convince me, because when I read clause 11, which is the one that he's seeking to amend, it clearly says that the registrar is then mandated under the proposed section 14(1)(a), 14(a)(4) to remove the name of the member from the register within 7 days. Okay? It further goes and says, where the registrar is not satisfied with party decision, the registrar shall refer the matter back to the concerned political party for reconsideration. So the question that I'd like some clarity on is that you're seeking now to have a period where, when the member has been either suspended, expelled, or has resigned, there's another period of 14 days to allow him to follow through the due process, 21 days. What about these 7 days where the registrar has been given? What about this other rider that the registrar has to be satisfied? Doesn't that help in any way?
Yes, Senator Murkomen.
To support, and for the record, this is one thing I would like to convince us to support. Senator Lekina has asked a very important clarification. The 7 days is the period within which the registrar must act. So let me put it this way. The party has sat down, they have had its disciplinary committee meeting and expelled member X. So they sent the letter to registrar, telling the registrar, Mr. X or Ms. X has been removed from our register. Please effect that removal. Delete them or remove their names from the register of the political parties. When the registrar receives, she or he has 7 days to act. So they act within the 7 days. Now assume they act the first day or even the last day. That is not my problem. Once they act by saying yes, and they have accepted, they say yes, we're expelling Mr. or Ms. X. I'm saying that expulsion should take effect 21 days from the day of the Gazette removing your name. From the Gazette notice removing your name from the register. The point is this. The registrar now sends gazettes your removal. Mr. X is being removed. Sends to the government printer. When they send, they say, from this day on 26th of January 2022, from 21 days from this day, your name will cease being in the register. Now, these 21 days is what gives you the opportunity now to seek legal redress. And if you don't succeed, in 21 days, you are done. Senator Orengo appreciates this position, but says it's up to you to run around the courts. But as I told you, in the case of Mwaura, we ran around the courts. But the time between his Jubilee expelling him and registrar gazetting his expulsion, so on a Monday afternoon, he's expelled, and registrar gazettes his expulsion, and the speaker communicates the next day that he has been expelled before we got an order. What only saved him is that there was a period between he was already removed, but his replacement did not take effect in good time. The person who was coming to replace him did not happen in good time. If it had happened that fast, Mwaura today would be in courts seeking to come back because he would not get legal redress in the interim. And gladly, the High Court also acted very fast. Justice Sergon did a good thing to make his decision within 3 months. Other judges and courts, if they took 6 or 8 months or 10 months, maybe we'll still be now in court waiting for that decision, and then we'll go to next election before it's put in place. So this is something I am begging to explain to us. And I jokingly say to Orengo if he becomes a governor, but any of us who is going to be a governor here, this is the power political parties use if they are unhappy with you. So they want to impeach you, But you become difficult because you are working with a certain number of MCAs who are supporting you. What the party do, they resort to their political party, put in place a kangaroo process, and expel the members who are with you. Now, if you run to court and they move the same speed, they will just expel those people, and then the impeachment process for the governor takes place very fast. This thing is useful to all of us in many ways, as individuals or as governors or people who are interested in governance or well-being of our counties.
Senator Faki.
Thank you, Madam Chair. I also seeking a clarification. You know, there is due process throughout the Act. Even under the Fair Administration Act and the Constitution, they provide for a due process. I think this amendment that my learned friend, Senator Murkomen, wants to bring is to maybe have another protection, another level of protection after the judgment. It's like saying that in a criminal trial, once somebody is convicted, we give a notice of that conviction, that so-and-so is convicted, and now he's going to serve time in committee prison from 21 days from now, which is not possible, because immediately that the decision is made, it's supposed to take effect. And maybe it's up to you now to run to the courts within the 7 days, that is the window of 7 days, to run to the court and protect your interest. But giving another 7 days, it appears as if maybe the member was not aware of those proceedings that are taking place before the political parties tribunal or even before the court, where the decision is now made for the member to be expelled or to be removed from the party. So I think the 7 days or the 21 days, I don't think it will be a viable position, Madam Speaker. Thank you.
I put the question that clause 11 be amended as proposed, division at the end. Senator Mwaura, further amendment? We'll drop that one.
Clauses 12 to 19.
I propose the question that clauses 12 to 19 be part of the bill. I put the question that clauses 12 to 19 be part of the bill. Division at the end.
Clause 20.
I propose the question that clause 20 be part of the bill. Senator Sherargei.
Whip, you are paid to be here and you have a government car. Madam Chair, clause 20, when you look at clause 20, they want section 30 of the principal act amended by deleting words 60 and substituting therefore words with 90. Madam Chair, clause 20 of the bill be amended by deleting the words 90, appearing immediately after the words therefore the word and substituting therefore the word with 30 days, Madam Chair. The clarification on this is that we should not force, in quotes, coalition agreements to be done within 3 months. And I know the National Assembly reduced from 120 days to 90 days. The import is that we should allow coalition of parties, in the clarification of this, is that we should reduce at least 30 days too, because when coalition of political parties come together and they want to run jointly for a general election in the Republic of Kenya, 30 days is more than sufficient, because what they need to do is to draft that coalition agreement, agree on terms of engagement, come up with the deposit either before, and that is at least 30 days before the general election. That should be around July. They deposit that coalition agreement. It applies similar, mutatis mutandis, immediately after the general election, 30 days, so that you don't need to pressure, because, Madam Chair, what we are seeing at the moment is that we will be disallowing, because we know the nature of our politics. You can even see that civil servants, Madam Chair, they have been told to resign by 9th of February. So, and yet you need the coalitions to be made 90 days before the general election. It means even if civil servants would want to resign and form a political party, then come and form a coalition party or a coalition agreement. Madam Speaker, that period of 90 days is a bit pressing and stifling the growth of democracy, because we need people to make their decision as practical as possible. And you know, Madam Chair, apart from this unique general election of 2022, where the winners are known now, you can tell that in the past, a month or even weeks to the general election, the winner is already Chair.
I propose the question that clause 20 be amended as proposed. Senator Aaron Cheriot.
Madam Speaker, you know, I go ahead. I was listening to these people who want this rope so badly. Because I want to see their faces after 22nd of April, once they have equally been hanged across their counties, especially these ones. Anyway, Madam Speaker, I want, first of all, before making my submissions, to understand from Senator Cherargei why he wants 30 days. I thought this is business that can be transacted even within 2 weeks. You should open this window up to as late as even. Yeah.
Honorable Senators, can you give Senator Cheriot time to execute his amendment while he is supporting that amendment?
Or you can first go to look for Kwamboka up there. There is something she needs to see you, then you come back later.
Now you are getting out of order.
Anyway, Madam Speaker, this is a point that I wanted Senator Cherargei to clarify for me. In our political seasons, we have seen actually coalitions being formed up to the last week before the general election. If you remember 2013, within the same week, certain political players cast their lot with one side of the coalition at KICC, I think about 2 weeks before the election, then before quickly crossing over to Jivanji Gardens to join the eventual winning coalition, that's the Jubilee coalition. So, Senator Cherargei needs to convince us, those of us who want to support his amendment, why 30 days? I thought he should even leave it to the last week before the general election. And also, leave it to the discretion of those who want to deposit. Because at the end of the day, like we have said...
Senator, I thought Senator Cherargei took a lot of time explaining that.
No. He explained from 60 to 30. You know, I know the table... You should tell Lawrence at the table of...
You are now...
Yeah, because, you know, you're not... you need to follow my trail of thought. Cherargei explained from 60 to 30.
I was really listening, and I had him explain...
Up to 30 days.
Up to 30 days. So
yes.
you wanted it to
my
shorten
question
it?
is, why 30? Not even the last 7 days of a coalition. So it's a completely different matter.
Senator Cherargei, can you explain again why not less?
Madam Chair, this
intervention.
Just a quick
There's an intervention by Senator Argura.
Okay.
Madam Chair.
Okay, yes. Thank you, Madam Chair. I just wanted Senator Cherargei to be very clear, because if I look at the original bill, not the bill, but the act which is being amended, Section 30 says, yes, but what is 60 days? It says a political party shall, at least 60 days before a general election, submit to the registrar a register of its members. It's not about coalition. A register of its members and a statement of its assets and liabilities in the prescribed form. So when you see that register is required when somebody is moving from one party to another. 30 of the act, which is being amended. So it's not about coalition agreement, or it's membership register. And I think it should be given as early as possible so that when a member is moving from a party to another, the registrar has a register to check against you. But if you say give it 30 days, somebody will even be locked out because you'll be told you are in the wrong party because the register is not there.
Senator, continue.
Chair.
Madam Chair, I think
Please put intervention. If you want an intervention,
Yes, Madam
yeah,
Chair.
Senator Xiong.
Madam Chair, it's just a concern that the two members, if you look at the rhythm, the way the pattern is, it's a matter of maybe coming here and probably entertaining questions. The questions are good, the discussion is good, but surely why can't they side chat and then come here, other than all of us just being interested in the two patterns? I know it is good, it's healthy, but for the two, but a matter of days.
Senator Cherargei, continue. More comment?
Madam Chair, is it in order? And I want you, Madam Chair, to be very firm on this. Is it in order for Senator Sionga, Madam Speaker, Masitsa Sionga Naomi, to, Madam Speaker, try to insinuate that we should convert this very important Senate to be like Chwele Market, where people converse outside before coming to sell their produce. When, Madam Speaker, what we are doing here will be read by our children, the children of our children, the children and children, and many generations beyond about the things we put here on record, and that each one of us who's here is not speaking to themselves, but speaking to the Senate.
Senator, I think that's concluded. Who was on the? Who was going? Yeah, but please, this back and forth, we are not going to entertain it, because it, it cannot be just explaining the same thing back and forth. You better just do the right thing. You come here and tell us why the amendment, and if you're supporting or not supporting, just tell us why you're not. But we are getting into too much back and forth and wasting a lot of time. Senator Cherargei, please, I'm giving you a final.
What I'm saying, Madam Chair, and I think it's a very important process because we are making laws. These are house of laws, and the legislative process must be followed. Madam Chair, if we use shortcuts, the courts of laws will embarrass us because they will go and overturn the laws we are making. And then we will accuse judiciary that they are making laws instead of us. What I'm just saying is that by the time you bring in the party register, the registration of members, depositing those, that is why those 30 days are more than sufficient. Because you can know with the technology, there is that transfer through the e-citizen, and therefore it is important that it does not need to be a lot of days. It can still be done within 30 days, and the efficiency of technology, Madam Chair, should be more important. So what I'm just saying is that this issue of production of, and party register and all these documents that is needed to process coalition, engagement, and agreements within political parties can be done within 30 days, and therefore it should not be longer than that, because political parties will know their formation of building coalitions within 30 days, or even we know it has been 1 week or less days before, Madam Chair, and therefore I think that is what I just wanted to clarify.
Senator Cheruiyot, please conclude.
Madam Chair, I'm now convinced that the period that is specifying, that is 30 days, will take care of all the challenges that I was foreseeing actually if you perhaps move it closer. But with 30 days, I'm fine. Therefore, I support his amendment. Thank you, Madam Speaker.
I put the question that clause 20 be amended as proposed. Okay, please, 1 minute. Timing these comments.
Chair, there is no standing order that gives the Speaker or the Chair to determine the period of speaking.
Yeah, but it's not going to be back
Yeah,
and
but
forth.
I'm just
so
saying,
just make your comment.
It's not back and forth, but I'm saying the chair cannot determine the time. Madam Chair, the first thing I want to say is that I agree with Senator Cherargei that the time should be reduced. But like I contributed earlier, I think the time should even be reduced to 1 week. 7 days. To 7 days. Why? Because you must give people an opportunity to continue voting for the party they choose, and they must continue enjoying that choice even up to the day of the election, of the nomination. Now, that is one. Two, if you look at that list, the party list, and Senator Argura captured it well, they are saying 90 days before. Chair, and I want these proposals to follow this thing. They're saying 90 days. When is today, Madam Chair? It's 26th of January. So meaning 26th of February, 26th of March, 26th of April. Those 90 days would have lapsed by the time this law is coming into effect. Even for your own goods, for your own sake. The 90 days will lapse. First of all, you are saying, even while we are being told to sit here, maybe you want to harass us, finish this thing today. The president is waiting to sign tomorrow. It becomes law. You are now going to tell members to represent the list 90 days before elections. Meanwhile, those 90 days have already passed. What kind of madness is this? So instead of moving to 90, we should move this thing to 20 days, 10 days. What will you tell people of Kisumu, Madam Chair, where ODM is very popular? Forget about this sugarcoating with Azimio. That's an ODM zone. That you tell them that the register of the members that are supposed to vote in Kisumu County has only, out of 500,000 voters, Kisumu is 500, or is it around there? Now 700,000 voters. The ones who are in that this is the most popular party in this region. Give people a chance. Give them to arrive at the polling station the same morning and say, I'm moving to ODM today and I'm voting for ODM. And he's put in the register, given certificate, and he goes. What this does, and I'm just being frank, and the registrar of political parties, as I said, the same, when she appeared before the committee about the challenges of implementation. What this does, in areas where either to certain parties were popular, it makes the voters get disenfranchised, because they would reach polling station, they will be told, you are not in ODM register, you are not in UDA register, you are not in ANC register, you are not in Fort Kenya register. Now they leave disenfranchised, and they go look for other political parties or independent candidates to vote for when they don't have a chance to determine the person being voted in the party they are popular. Let's not, I don't know. Can you, these people of Azimio, tell us what wisdom drove you to give us 90?
Senator Nderitu?
They don't even know.
I was just concerned with whether Kipchumba Murkomen is supporting Senator Cherargei amendment as well as Senator Cheriot, because we need to be specific to know whether they're talking about 7 days or 30 days, because now that's
I think they were just, they were asking for further clarifications, but it's on the same.
Okay, so I've clarified on behalf of Cherargei, 7 days.
I propose the question that clause 20. I put the question that clause 20 be amended as proposed, division at the end.
Clause 21.
I propose the question that clause 21 be part of the bill. I put the question that clause 21 be part of the bill, division at the end.
Clause 22.
I propose the question that clause 22 be part of the bill. Senator Irungu Kangata? It's not, it's online? It's not online. It's, yes. It's not online. you know, okay, go ahead.
Yeah, thank you. Madam Speaker, Senator Irungu Kangata mentioned to me that he's online, and when it gets to the point of this amendment, he would request to be allowed. But if it happens, because he says where he is, there's challenges of stability of internet, that I move the amendment on his behalf, just like Senator Ledamo Lekina wanted to do on behalf of Senator Wambua. So if I can be granted, I'll do that.
Honorable Senator, we've just disallowed that previously. So we are doing,
no, because he was not there.
We are not allowing that amendment
no,
because
Madam
there's
Speaker,
no communication.
Surely.
We are not going to allow that.
No, Madam Speaker, honestly.
Because you allowed, just rejected.
But you allowed him.
No, it was not.
It was allowed because Senator Wambua was not here. But this one I have mentioned to you that he has requested that I move on his behalf.
Senator Wambua had informed the clerk's office. Has he informed the clerk's office?
I think so. We need to take a minute and clarify.
Just check
Can
that
you clarify?
Just check it, please.
No, it's not my work, Madam Speaker, to check.
Let us check it. We are going to check and come back to you.
Don't drop his amendment until you check.
Fine, we are going to check that one. Further amendment proposed by Senator Kipchumba Murkomen.
This is the real deal, Madam Chair. If this bill is going to collapse in another 1 week, and I don't think it will take a week, if it ever reaches a stage of being a law, it will be because of this section. I'm not a judge. I am not intending to go to court, but I know Kenyans of goodwill who appeared before the committee were very particular about this section. That is clause 22. Madam Chair, if you read Article 88 of the Constitution about Independent Electoral and Boundaries Commission, it says,
yes, Senator Faria.
Did you hear Senator for Elgeyo Marakwet calling us robots? He said the robots don't care to listen. Yes, you said.
Robots, me.
We will check the answer.
I suspect
Can the answer be checked?
I suspect that Senator Faria, Madam Speaker, is not appreciating what I'm doing. I'm a very senior member of this House. She came the other day. Madam Chair, she must know that I know the procedure. You can't call people robots. You can't call people robots. It's not acceptable.
Yeah, that can be verified. So just continue.
Although maybe there is something ringing in his head that says, I am a robot, and he thinks I'm confirming. But I have not said, Madam Speaker. I haven't said anything of that sort. Madam Speaker, I have said, unless there's something playing in her head, but I never said it.
Senator Murkomen, continue.
Thank you, Senator Mazzayo. Judge, this is a very serious issue. Madam Chair, if you read at the functions of the Independent Electoral and Boundaries Commission, you'll read in 88 and elections to any elective body or office established by this Constitution, and any other elections as prescribed by the Act of Parliament, and in particular for continuous registration, continuous registration of citizens and voters, that one is not an issue here. Regular revision of voters' roll, delimitation of constitutional awards, that's okay. The regulation of the process by which parties nominate candidates for elections. The regulation of the process by which parties nominate candidates for elections. Now, if you look at article, clause 22, sorry, Madam Chair, I'm mixing many things, articles, rules. So, 22C, it says that you insert a new clause, which is the function of the registrar. This one, even a constitutional law student, a first year one, would have known that this drafting is, I really want to establish who drafted such a thing. Because it says, certify an independent candidate in an election is not a member of a registered political party. Independent candidates are supposed to be themselves, the ones presenting themselves before IEBC. And I'm just saying, the first one is certified independent candidates and election. He's not a member. So you appear before IEBC, you are told, you present yourself and say, I'm independent. You are told, no, go back to register political parties. In the first place, you decided you are not going to be a member of any political party. But now you're being told, go and clear yourself that you are not a political party. It's like you're not going to register an NGO. Then they tell you first go and establish that you are not a company. Then you come to the NGO board to be registered. Number 2, certify that the symbol intended to be used by an independent candidate in an election does not resemble the symbol of a registered political party. Okay? 3, certify that the names appearing in a party list are the names of members of the political party presenting the party list. The next one, regulate. Now this is where the demon itself lives. Regulate political party nomination in accordance with this act. The regulation and process by which parties nominate candidates is a function of IEBC under the Constitution of the Republic of Kenya. ORPP just keeps register of members of political party. They have no responsibility in regulating elections. They have no role. They are not an election body. In fact, that's why the political parties establish under their constitutions a body like election board, like the one Judy Pareno managed for a long period of time. They manage the elections internally, and they are respected because it's an institution of law. They manage the elections on their own. And the final one, train political party election agent upon the request and financing by political party, if they do or if they don't. But if I don't want to be registered by the registrar, to be trained by the regional political party, that is not a legal requirement. It's not something that I should put in law. So, Madam Chair, I am simply saying, ladies and gentlemen, let us demonstrate to Kenyans that we also went to school like the judges that are sitting, that will sit upon the decision of this law, and tell Kenyans that we do not have, because I conversed with a friend of mine who told me in the National Assembly, they saw this thing as it is and they said, why make a lot of noise and complain? Let them pass if they want. And then it got burdened in the courts with a lot of cases. They are supposed to serve a lot of hustlers who have land cases, marriage cases, you know, so many other things, succession issues. We are now burdening them with theft and stealing, you know, robbery, land conflict. Now, all these things, we are overburdening the courts by taking these petitions to court that, honestly, we are here. Faki, Senator Faki, my friend, you cannot have been a senior lawyer. Senator Mazzayo, you know, in the opposition, now in government opposition, some oxymoron of some sort. You know, you couldn't have been in that situation in vain. Let's do the right thing and amend this thing so that we don't have to burden the country.
Yes, Senator Lekino.
So, Madam Chair, I'm saying I'm proposing to be deleted.
Okay.
Senator, be brief.
Madam Chair, I wouldn't be wasting my time if these proceedings were not live and the whole Republic is watching. But I think I just want some clarification from the distinguished senator. Are you saying that to use the term certify that the symbol intended to be used by an independent candidate in an election does not resemble the symbol of a registered political party is a waste of time for the registered political parties? Why? Can you just clarify this? Because, you know, the reason why, we are creating this amendment, I had indicated earlier on, is because we want discipline in political parties. We don't want a situation where someone participates in a nomination and then tomorrow runs again. So when you run to the political parties, to the registrar political parties, you need to be certified that you are not a registered member of a political party. I think the act is very clear. The rules are very clear that the registrar of political party shall maintain a certified register of members of a political party. We don't want a situation. So if the distinguished senator wants us to delete this proposal, can you then tell us how do you propose the registrar of political party handles members who are registered in 2 political parties and want to participate in 2 political parties' nominations to continue putting in discipline. So who controls it? The second issue that you raised is the issue of regulate political party nominations in accordance with this act. Are you saying, in the simple definition, English definition of regulate, it's just to control, that they are doing the right thing? It is not in terms of regulations, setting up regulation. It is, you're defining it wrongly from the way it has been defined in the Constitution, or the Act, or the Constitution has mandated IEBC to do that. Can we just be a little bit clearer? Because the nation is watching. We want to be sure that this Senate is actually enacting legislations which are clear. Because when I read this, clause 22 of the bill, and Madam Chair, I just want the distinguished senator to explain. You say clause 22 of the bill seek to amend section 34 of the Act to allow for the following additional functions to the registrar. Functions. Number 1, keep and maintain a register of members of the registered political parties. Are you now seeking, because you want us to delete that, do you want IEBC to keep that list? That's number 1. Number 2, you are saying certify that an independent candidate in an election is not a member of any registered political party. Who then do you intend to certify that? Is it IEBC? I would assume that it is the registrar of political parties, because this act is the one that mandates political parties to submit lists of their members. And when you go through a nomination exercise, you have to get a certified copy of the registered members from the registrar of political parties, so that it can stop this business where today you, as Senator Murkomen, a member of UDA, and then Senator okay, a member of UDA, okay, you have to go on record. But in this case, Madam Chair, it's a hypothetical situation so that we can clarify this issue. We don't want a situation where you go out there, you register 50 members in your political party, and then your friend who is running for an MCA but in another political party comes and tells you, give me those members so that I go register them for nomination. And they are members of another political party. So I think if you want to convince us, and this is what you should be doing, if you want to convince us, and we're happy to be convinced, because we don't want to waste the court time. And I really do hope the courts are also listening. Because the way you're interpreting these words, this clause, is actually wrong. So I would request that you read it carefully. And then when you're trying to seek our support in the amendment, you do so in a way that even us will know that this is a problem. But the way it is right now, it is only seeking to assist in making sure that there is discipline. And I'll repeat, discipline.
I would like to give Senator Cheriot, because before Senator Murkomen reacts, so that when he reacts on everything. Yes. Yes,
I still want to emphasize, during the committee, the proceedings of the committee of the whole House, people are supposed to put pointed questions. Pointed questions, not elicit questions for debate, because the debate ended during the second reading. We're now not even in the third reading. Unfortunately, at the moment, 3 members of parliament are talking to each other. Yeah, it is Cheriot. No, it is not the country is watching. You're talking amongst yourselves. But we want you to give us an opportunity to interrogate. Yeah, but you are talking to yourselves. So I'm saying, really, because this is about legislation. Madam Chair, I plead with you that give them as much time as possible, but let them ask pointed questions, which should not take a minute. These days, everywhere, people assign time. That's why people are given 3 minutes, 5 minutes, half an hour. So this is going to be the dictatorship of 3 people holding us at ransom because they want to talk until tomorrow. No, I'm on a point of order. Yeah, please. Please sit down, sit down, sit down. Yeah. So I just need your direction that let them give us an opportunity, because they're the ones who are moving the amendments. They are the ones who are moving. But now it is time for us to interrogate the amendments. But they are not giving us time to interrogate those amendments. They are talking amongst themselves, and I think that should be brought to an end.
Yeah, Honorable Senators, I think this issue we have talked about it on several times. So if we are not going just to have back and forth on the same issue and the same people speaking, we have talked about it more than 4 times. So,
Madam Speaker, you see, you are being misled.
I'm not being misled, and please don't.
I don't have an amendment, but I have a duty to legislate. Therefore, any amendment that is brought on the floor of the House, I'm duty bound to react.
But you're not doing in the manner that it should be done.
I don't understand under which standing order James Orengo wants to bandy us all together and say
no. That is not the issue. What we are saying that if you are supporting an amendment or not supporting, just be brief and tell us why you are supporting or why you are not supporting, and don't engage in further debates. That's what we are saying.
If it is about time, Madam Speaker.
It's not about time.
If it's about time.
But it's about doing the right thing.
Yes.
So just tell us why you are supporting and be brief and let others also interrogate. That's how it should be done. Please, you have not even put intervention. You have not even put intervention. So let him first of all finish, then it is you.
They cannot embarrass the chair. You are speaking and they are speaking at the same time.
No, that is not acceptable.
You cannot intimidate the chair.
No, because
Chair, you are
just do.
Chair, you are not intimidatable. Chair, I know you are unbogable. Nobody can boggle you.
No, Senator,
Sir,
just
Chair, on a serious note,
on
a serious note. Senator Orengo, on a point she has given me.
It's on intervention. I will give you the chance, Senator Pareno.
Thank you, Chair.
Yeah.
By the way, Chair, you've done a fantastic job. There is no other chair who has done this. And I'm not flattering you. I have been in this house for 9 years. You have done a fantastic job. Chair, Senator Orengo is, yeah, she did better than me many years ago when I was there. Madam Chair, and you always appreciate people if they do better. Madam Chair, I have Senator Orengo, you must rule Senator Orengo out of order. Because Senator Orengo has said we are stopping other people from interrogating the bill. But Senator Orengo has only interrogated one clause, and it is his right. The rest of the members here are seated, and they seem to be waiting for something. It must be a vote. It's only Senator Orengo and Senator Ledama who have interrogated this bill. The rest are quiet. If Senator Cherargei and Senator Cheriot and Senator Mahmoud and Senator Kinywa are enthusiastic enough to take the responsibility seriously, should they be punished because Senator Orengo is keeping quiet so that we don't talk? It's also out of order.
Yes, Senator. No. You've been talking here the whole afternoon. You've been talking here the whole afternoon. Just have your seat. No.
You sit down also.
Just sit down. I will give you that. And I've been giving you your opportunity.
Yeah.
I will give you.
Madam Speaker, you remember in relation to Clause 11, and I was carrying my books here to try to respond to the issue raised on Clause 11. I've not been quiet here. Yeah, but what I'm saying is that the amendments are there in the order paper. In fact, most of the time during the committee you say, I move in accordance with what is in the order paper. But what is being done now is a strategy towards 3 members taking the time of three senators talking amongst themselves and not allowing us to interrogate what they are trying to move to the House. So, Madam Speaker, Madam Chair, I think this should be brought to an end so that those who want to interrogate, not the people who are coming to say, I support, like Cheriot, throughout, you have been standing only to support and not to interrogate.
Madam Speaker, is Senator James Orengo Madam Speaker.
Okay, say whatever you want to say. I would like to give a ruling on this.
Yeah, but there's something he has mentioned me, so I want to respond.
Go right
Madam
ahead.
Speaker, you see, every time I have come to this floor, it has been under your direction. Is Senator James Orengo accusing you, as a chair of this session, that there are people who have requested the chance just like us to speak, and you have denied them? Otherwise, I have no ability to deny anyone the chance.
I think now we are getting into arguments. Let's not get into arguments. Senator Pareno, what is your point of intervention?
Can you explain how we are stopping other members from participating?
Yes,
my
Senator
point
Pareno.
of order, Madam Chair. How do we expect to conduct business in this manner when every other minute before you even give Senator Cheruiyot to stand up, before you even give him the mic, he's already there taking the mic and arguing with you? Madam Chair, you must rule on this. People must be orderly as we continue to do business in this house.
I'm not ascribing, I mean, it is your responsibility. I should give you point of order, but please let's make progress. What's your point of order, Senator Nderitu?
Madam Chair, I've listened to Senator Orengo saying that only some people who are speaking. I have been here listening. I have heard Senator Lekina speaking. I have heard Senator Faki speaking. I have heard Senator Engineer Hagura speaking. I have heard Senator Cheruiyot speaking. I have heard Senator Cherargei speaking. Madam Speaker, Senator Orengo must have walked out and he has just walked in. We are all participating. So please, you should allow people to continue.
Honorable Senators, I have heard all your comments. We are at the committee stage. The next person that I will give an opportunity will have to state why they are making the amendments and the reason, as simple as that. And anybody supporting will stand and say why they are supporting or not supporting. In not less than 3 sentences. We are not going to have debates. Yes, Senator Fokiambu.
Somebody was asking why it's just from one community.
Madam Chair, I want first to agree with what Senator Murkomen said, that indeed, Madam Chair, you've done very well in managing the process. That one I entirely agree with Senator Murkomen. But
Honorable Senators, when you are talking, people listen. Can we give each other an opportunity to say whatever we want to say?
Yes, Madam
Yes,
Chair,
Senator Wamutanga.
actually, I said that I do support what Senator Murkomen has said. You have done very, very well. Indeed, even Senator Murkomen, Senator Cherargei, Senator Cheruiyot, in the amendments they have put, they have executed their legislative mandate here very, very well. But Madam Chair, Madam Chair, the process must have an end. And at the end of the day, indeed, the expectations of the senators are such that by the close of this debate by midnight, that there will be a vote on those amendments, Madam Chair. And that is why I would want to propose, because, Madam Chair, allow me to remind all of us here, that at the beginning of the debate here, we said that this house is going to be different from what the other house did. And so we cannot exchange the shame of blows and fists and biting into name-calling, time-dragging, gimmicks, Madam Chair, that will be shameful. Let us expedite this process. I want to urge all the members who will be contributing and supporting, Madam Chair, that when we come here, expedite your process, say the things you want to say, wait for members then to vote, but let us be honorable, let us be respectable, let us do the business of passing the laws we want to pass, and uphold the status of this house, Madam Chair, as it has been. Madam Chair, I want to support that indeed you be firm so that we move quickly, allow everybody to speak, but let them speak definitively, decisively, and conclusively, Madam Chair.
Thank you, Senator. I think we have canvassed enough on that amendment, and now I put the question. First of all, you've gone back and forth until such that you go. No. Can you sit down? Go and sit down. Both of you should. No, you sit down. Go sit down. I have made a decision on that, and I put the question that clause 22 be amended as proposed. Division at the end. Next.
Clause 23.
I propose the question that clause 23 be part of the bill. I put the question that clause 23 be part of the bill, division at the end.
Clause 24.
I propose the question that clause 24 be part of the bill. Senator Kipchumba Murkomen. Please. Please take your seat. Take your seat. Take your seat. Take your seat.
Madam Chair.
You cannot be standing there and arguing.
Madam Chair.
You can't be there and arguing. No.
Chair.
You sit down.
Madam Chair,
Clause
do not
24.
allow somebody to...
Can you sit down? No. Senator Murkomen. Senator Murkomen.
Chair.
Kindly,
Chair.
just continue.
Before, Madam Chair.
And I've given the direction on how we move forward.
You have. I have heard you. I've heard you. I know how this house runs. And when you go wrong, you must be ready to be told you are wrong. You are a chair. You can't say that you are absolute. You are not. You are guided by standing orders. I am still waiting for clarification from Senator Cheriot on 22 and Senator Cherargei and Senator Mahmoud. How did you jump? How did you jump?
We cannot deliberate on one issue back and forth by only 3 members. It will not work. No.
Madam Chair, Senator Cheriot was already on the floor. I had my pen and paper waiting for his clarification. Senator Orengo raised a point of order, and by virtue of his point of order, you remove a member from the floor. How do you trust?
Can you make the next amendment?
How do I make it before I listen to the other one?
We are going to just make that amendment.
Madam Chair, under what standing order will I proceed to deny my colleagues? No, under what standing order?
We will come back to that later, but for now, No.
This is serious,
We are
Madam
still
Chair.
here.
Madam Chair.
There are amendments that we have skipped.
Madam Chair, you people are already many. So leave us to make our case. We don't want... Senator Orengo, I told you, don't heckle. Don't heckle. You need this. You need what I'm saying more than the time you are rushing. And next time, Chair. Next time, Chair.
Let's have some order.
Next time.
Let's have order. Senator,
have some order.
Who called you? Nobody called you.
No, just have your seat, please.
This is a committee, this is not speaker. Madam
Senator
Chair, next time, Madam Chair. Chair. Next time, can you protect me? I can't even hear myself.
Yeah, but it's the same people. Yes, Senator Wamatangi, what is your point?
Madam Chair, can I senators, can you sit down, please? Madam Chair, I propose.
Please, let's have order. Let's have order. We are not going to entertain disorderly.
Madam Chair, I propose, because the amendments that are being prosecuted here are documented in the order paper, Madam Chair. And the fact is that they all have to go through the process of this House of being heard. And that guarantees that every member will have an opportunity to prosecute. Madam Chair, can I propose, as we normally do, that then we have a time allocation for each, such that if we agree it is 50, Madam Chair, you know, there's only one chair in this. Madam Chair, we are not saying that anybody is stopped from making their contribution. They should. But at the end of the day, this must end by midnight. And so within those amendments, Madam Chair, can we, each amendment, to take a maximum of at least 15 minutes? And then, and Madam Chair, if the House so resolves, because I'm making a proposal, that we have that as 10 minutes, so be it, because it's the House that will decide. But what we need to have is surety that when we look at one amendment, it will take a certain time for it to close. Otherwise, we will continue to go round and round and never conclude the business at the end of the day. And you know, Madam Speaker, but the point we need all to appreciate is these members, that even if it takes 2 years, it will still have to close.
even if it takes whatever time. So the sooner we close it, the better. So, Madam Speaker, my proposal.
I think your proposal is well put.
Yes, Madam Speaker. So I want to propose, Madam Chair, and I want to move, Madam Chair, that for each of the amendments that we have, that the House, Madam Chair, allocates, Madam Chair, 10 minutes for each of the amendments so that we prosecute it and move. And I propose, Madam Chair, that Senator Kavindu.
Let me make a comment on that. What I'm saying is initially, no, I've not given you an opportunity. What I'm saying, and initially had suggested that we put timeline, and members said no, there's no standing order to timeline. But the problem we have, we are not going by the rule that if you are proposing an amendment, stick to the reason why you are making an amendment. And if you are supporting or not supporting, just say it. It will not take 15 minutes. It will take less than 5 minutes. How many minutes per member? No, what I'm saying, we should just go by the rule. And the rule says, just state why. It will take a very short time, members.
Speaker, I've just made a reference to Esken and May, which is the Holy Grail, insofar as parliamentary proceedings are. If you go to the American way, during the committee stage, you see they are not even listening. They're not even listening. They're not listening. In the American system, you can filibuster even during committee. You can take as much time as possible. You can filibuster for a whole year. But under the parliamentary system, which we inherited in the Commonwealth, is that Westminster model, is that during the committee stage, the person during the committee stage of the whole House, the person who is proposing the amendment gives justification for that amendment, and only those who are seeking clarification. And by the way, clarification is not saying I'm supporting it, because now you're engaged in the debate. So anybody standing up, to comment on a proposed amendment should be somebody standing up and saying, I'm seeking clarification on the text, because now we have a text, but now we are having a general debate. And that general debate, we can go on forever. It's now not a committee of the whole House. It's like a baraza now. We have turned a committee of the whole House into a baraza. Anybody can say anything. So, Madam Chair, I'm asking you, and the senator is already putting his hands up. They stand up anytime and shout anytime while we are sitting. Yeah, we are sitting here, and you're making, you're saying anything that you want to say. And others, we are not lesser beings. And we are sitting down to listen to you. We are not lesser beings. So what I'm proposing.
Honorable members, please let's have order.
What I'm proposing.
Let's have some order.
What I'm proposing, Madam Speaker, we'll have to go through all the amendments.
Chair, the clarification that I need from Senator Murkomen, and help me understand, because of
you see, now you are taking us back there.
No, but it's not my amendment. It is his amendment. So clarifications are for him about clause 22. Madam Speaker, I need to understand. Madam Speaker, can you protect me from the majority leader who was once a victim of this same law?
Kindly, please let's not divert attention. Let's just, I've given you 2 minutes. Your 2 minutes will be over. Speaker, then I will make a ruling.
How will I proceed if Senator Pogise is interrupting me? Kwamboka is here shouting.
Senator Kwamboka, let's have some order. Let's all of us have some order.
Yeah, please.
And I'm giving you just 2 minutes to get that clarification from Senator Murkomen.
I will do it. Madam Speaker, we need to understand Article 88 of our Constitution that sets up the IBC, subsection 4E. The regulations, he has begun once again, Madam Speaker.
Just continue. I'm checking on him. Just
sit somewhere and purports to send a legislation to this House wanting to transfer a constitutionally granted power to an independent constitution to some office called the Office of the Registrar of Political Parties, Madam Speaker. If that is the reason,
we are going by our agreement, if that is, as Senator Murkomen, the area where you need
But
clarification.
2 minutes are not yet over, Madam Speaker. I was on 1 minute and 1 second, then you interrupted. So give me my 58 seconds.
Go ahead.
So I need to understand, Madam Speaker, if we have gotten to a point where we want to seize, instead of granting additional power to independently set up constitutional offices and setting it in the hands of a single individual, who on the whims of the politics of the day can make a decision that can be so fatal to us political practitioners. Is it for that reason that Senator Murkomen is moving his amendment? Because if that is a reason upon which he's sending, then no, it could be for another reason, Senator James Orengo. You know, Kericho people don't...
Conclude.
Okay. I want to conclude, but I'll conclude if Senator James Orengo can grant me the...
Peace that you want.
Peace. You know,
okay.
It's difficult to talk when you're being interrupted.
I think Senator Murkomen should respond to that.
Okay. Thank you. Thank you. Thank you, Madam Speaker.
Thank you. Senator Murkomen, please.
No, Madam Chair, you can see the majority leader making a lot of noise. If history will be written of this House, it will be said there was a very silent majority leader who guides people on nothing in this chamber, speaks to
Senator,
nothing,
please.
speaks to no bill, and gets extremely irritated when debate of this House is going on.
Senator,
Madam Chair, let's be fact.
You know,
I am asking for a point of order, and this one is standing around behind me.
I can walk.
no, I think you are not a point of order. You are the one who was just clarification. Yes,
yeah.
Respond, please.
Please, can we have some intellectual leadership from the majority leader, not just coming here to vote? Madam Chair, the
Senator Murkomen, you are really getting out of order.
I am serious. I am very serious. I'm not out of order. I am extremely serious. We have a majority leader from the time he became majority leader who only comes here to come and vote.
I've given you a very good opportunity.
Yeah, so let me respond to my question.
Please respond. Senator Kwamboka, please.
And in the next...
You know, we are taking a very...
In the next... Madam Chair, let me respond, and it will take me 1 minute. But...
Now, no, I think these people are...
Madam Chair, quickly.
Senator Murkomen,
yes,
please say...
I can't hear even myself.
React.
Yeah. Madam Chair, if you look at the amendment... Yeah, if you look at the amendment provided, I made a statement of fact. It is incontrovertible. If you look at the amendment proposed, the objective, Madam Chair, is to protect the constitutional responsibility of IEBC. Once the member, Senator Cheriot, appreciates, like I did, and I don't want to take the time because time is of the essence, and I want to be concise. Once he appreciates the constitutional responsibility of IEBC under Article 88, then he will appreciate why I'm proposing that this be deleted from ORPP. If one wanted to strengthen, if you wanted to strengthen or be prescriptive insofar as how IEBC is going to perform that function of regulation, then move this to the function of IEBC. That's what I was saying. And Madam Chair, in the next Senate, I'll be proposing that apart from searching members at the gate, at the entrance there of this chamber, we must put there an alcohol law.
Majority Leader.
Madam Chair, you know for sure that Senator Murkomen is a very angry man, that he's not the majority leader. And it's not my fault, really. And he shows that anger every day, every day. Madam Chair, this member has talked about me without bringing a motion and should rule him out of order. He has discussed me. Look at that. And so, Madam Chair, I just want you to take control of this session. And please, I know that...
you know, we are really in control of the session. Yes. The problem is, I'm also guided by the rules.
Yes, but somebody cannot discuss me in your presence without a substantive motion. That you know that for sure. And, Madam Chair, this anger that Murkomen carries It is really causing a lot of problems, not only here, even outside here. He's still angry with me everywhere he goes. And I don't know, he has to deal with that anger. But he has to be also orderly. What makes it worse, Madam Chair, is that since he ceased to be the majority leader, he has behaved in a manner that you didn't know existed in him. And now, Madam Chair, the only thing I want to ask is, he debated me here, you should bring out that order that he cannot, Madam Chair, discuss a member without a substantive motion.
Honorable Senator Murkomen. No, we cannot do that. Senator Pareno, your point of order? That's okay. Now we move forward. I put the question that clause 22 be amended as proposed. 24.
Clause 24.
Okay. I propose the question that clause 24 be part of the bill. Senator Murkomen. No comments.
Madam Chair, I am prosecuting very serious parliamentary business. I am not angry. Yeah, so
please just make your comment. Yeah.
So not just I'm saying, and my colleague Senator Pogisho knows he has my full support. Only if you can be coming to the chambers to guide us, but you can't just come to vote. Madam Chair, if you look at Article 20, that 24. Sorry, I am proposing, Madam Chair, that clause 24 of the bill be amended by deleting Section 38A. I don't want to repeat that. 38A was I had already made my case at the definition section. If I'm not wrong, just hold on, Chair. That is 38A. Yes, 38A. I already made my proposal in the definition section that the reason why direct nomination and indirect nomination, that I don't believe it's part of the establishment of the registrar of political party to do this. So that's all. It's actually to cross-reference the initial amendment I proposed in section in clause 2. So that I'm trying to save time.
Okay.
If you look at section 38C, a registered member of a political party shall be entitled to participate in the nomination conducted by the political party. Now, the reason why I am saying 38C, which is 38C 1 to 6, from a registered member of a political party shall be entitled to participate in nomination conducted by a political party. A political party that intends to conduct shall use certified register of the nomination. Political intends to conduct political nominations under Act shall apply in writing to the registrar for a certified copy of a register of members of list 21 days before date of nomination. Then all that. All these proposals, Madam Chair, I find it, 5, a political party shall not allow any person who is not a registered member of the political party to participate in the party of nomination and so forth. I believe the intention is good. The intention is to ensure that the register being used by political parties is only confined to those who are inside the register participating in the nomination. But practically, that's not the story out there. Madam Chair, out there, most of the members of our political parties don't find themselves being part and parcel of the register. The registration process that is going on, even up to now, even today, we have thousands of members of the public who are in the register of the political parties that they did not choose. Now, if this becomes a condition, this becomes a strict condition for purpose of elections, I foresee a situation that many election petitions will be based on these requirements that have been here. What has happened before, the rules, before this drafting happened, the rules were a little bit relaxed, so that a member would come and register, I join ODM, then I vote, then they become part. And even in many of the cases, even 2017 and 2013, we allowed political parties to adopt the ISBC register as part of the register and allow members who like to vote because they associate with the party to come and vote. Madam Chair, I thought that it was unfortunate that these strict provisions are being brought in, but also being brought in closer to elections. If you remember, one of the most contentious issues that Curricular Commission raised was that don't change the rules too much close to the elections. Now the nominations are 3 months away, less than 3 months away, and you are putting these strict requirements for these political parties. What will happen, Madam Chair, is not just confusion will ensue, but also it will lead to a situation where the political parties will find themselves in so many petitions. That is for 38C. For 38E, this is notification, and this is where I find, again, based on my earlier arguments on the functions of ORPP vis-a-vis the functions of IBC. If you look at 38E, it says, a political party shall not less than 10 days before the date of party nomination notify the registrar in writing of methods it intends to use in conducting party nominations. Now, you're not writing to IBC that manages elections. Now, it has become the office of the registrar of political parties that is managing your nomination. So you are writing to them. The date of party nominations and all that procedure, the venue, the list of members who wish to nominate it, and so forth. I find this one completely in contravention of Article 88 of the Constitution. This is not a function of ORPP. This is a function of IBC. These are not my words. These are also the words of IBC chair when he presented before the committee, both in National Assembly and the Senate, that there was a heavy encroachment on the function of the constitutional function of IBC. And then we are being told at least 7 days before the date of nomination, a political party shall publish an official website, a registrar shall publish an official website, and all that. I don't have a problem with that. 38F, which I'm proposing also be deleted. A political party that intends to conduct direct nomination shall post and so forth and so forth. Again, I had already said this prescription of what a direct and indirect nomination is, so that I save the House time, is not necessary, because there are many methods of nomination. There are many methods that a party can apply for nomination. Confining it to what is now defined as direct and indirect, Madam Speaker, is constricting the space, democratic space, that the political parties could be able to apply. Lastly, 38G. You see, I'm very considerate, Chair. I am extremely considerate because you are a good chair. 38G, on the question of indirect party nominations. Again, for the similar reasons that I argued that these direct and indirect nominations are unnecessary. You can see this submitting of list of delegates and so forth to the registrar of political party, again, encroaching on the responsibility of IBC, but creating constriction of the political space that was not expected in the Constitution, and constricting also political rights against the Article 38 of the Constitution. Lastly, in that amendment, pardon? Yeah, not listed. Still more, it's still a very important point. Thank you, Senator Fak. 38H. A political party conducting party nomination shall ensure that each candidate who is nominated makes and deposits a self-declaration form of leadership and integrity, possesses qualification to hold elective office as specified in the Constitution, meets such other requirements as may be prescribed by the Constitution. Again, this is superfluous, Chair. There is already very clear provisions in the Elections Act of what one can present to the IBC, including this. This declaration of integrity is first unconstitutional because you cannot force people to go and say, I am of good integrity and so forth, Madam Chair. It is the responsibility of those who are contesting my integrity to bring provisions saying that I have been removed, I have committed an offense under Chapter 6 of the Constitution. By therefore, Madam Chair, I propose that Clause 24, Section 3A, Section 38C, Section 38E, Section 38F, Section 38G, and Section 38H be deleted.
I propose the question that clause 24 be amended as proposed. Now, before I put the question, if the amendment by Senator Murkomen is carried, then Senator Were, who I don't know if she's online or not, the amendment will not be moved. And Senator Cherargei's amendment will only be moved in respect of Part B, that is 38D. I put the question that clause 24 be amended as proposed, division at the end. Next. Senator Petronila Were is not available, so we drop the amendment. Senator Cherargei, move as far as 38D is concerned.
Madam Chair, I'm online.
Thank you, Chair.
I'm online. I don't know why somebody was
Can she
muting
come
me.
after me?
How come?
Okay, you will come after Senator. You will come. We are giving you an opportunity. Just 1 minute. Just 1 minute. Cherargei, just continue.
Madam Chair, I'm proposing that that clause 24, though Murkomen has expanded with it, is that that clause 24 of the bill be amended by deleting the proposed new section 38D. And it says a political party shall ensure that register of members used in any party nomination is accessible to the registered members of the party. And I think, Madam Chair, this is the consequence of Article 38C. As you are aware, it looks like registrar of political parties have been given unnecessary and powerful powers, which is duplicity of the role of the IEBC. And when you look at this register that they are talking about, is that that should be used, is that sometimes, and you know, office of registrar of political parties or registrar of political parties, the appointment process is normally done by the executive. And therefore, Madam Chair, in the inside, it means that if somebody wants to be mischievous and they want in a way or another, they will ensure that the registrar that political parties provides to the political parties by registrar of political parties can be skewed or can be mischievously ensure that the names that appear on the registrar that can be used in nomination of political or primaries, Madam Chair, can be used. And that is why it is dangerous that it will be easy if we pass the way it is that this House would be committing a political suicide. And therefore, Madam Chair, the effect of deleting section 38D on this clause 24 is that the practicability, even with the COVID, Madam Chair, you can imagine if you are to pin the registrar of members that have been the registrar of members of a political party, for example, like Kuzimia political party, and when you go there, Madam Chair, people are touching, people want to use, I think, Madam Chair, with technology and many other aspects, the effect of this must be deleted so that we become more practical, Madam Chair, and ensure that, because inside we have given, and what is the practicability that registrar of political parties will ensure those party lists are made accessible? Because, Madam Chair, if we are not careful, you can get a fake party list. How do we ensure that there is rigorous process? And I'm aware that the regulations and rules of this amendment has already been prepared by the executive, but will they be able to capture this and ensure that it has growth, Madam Chair? So I propose that deletion of section 38D, I think section 38C has been dispensed with, and I think, Chair, with those very many remarks I stated.
I propose the question that clause 24 be amended as proposed. I put the question that clause 24 be amended as proposed, division at the end. Senator Petronila Were to make an amendment. Can Senator be given mic? No? Okay, dropped. Next. 25.
Clauses 25, 26, and 27.
I propose the question that clauses 25, 26, and 27 be part of the bill. I put the question that clauses 25 to 27 be part of the bill. Division at the end.
Clause 28.
I propose the question that clause 28 be part of the bill. Senator Murkomen. (28)
Thank you, Madam Chair. If you look at clause 28 of the bill, we are trying to amend subsection A. Now, this is another area that I am very happy with, if you guys want to pass it as it is, to deal with it elsewhere. Madam Chair, if you look at subsection 2...
Honorable Senators, can we have some order, please?
Subsection 2 says, amending the section 41 of the Act, Principal Act, that to both the Court of Appeal and the Supreme Court, and substituting therefore the words of the Court of Appeal, and the decision of the Court of Appeal shall be final. In other words, Madam Chair, this is so straightforward, I don't even need to waste a lot of time. The Constitution provides the channel to which a citizen can take when you are appealing a matter from the magistrate courts to the High Court to Court of Appeal to the Supreme Court. This act is purporting, this actually amendment is purporting to amend the Constitution by doing away with the jurisdiction of the Supreme Court and limiting appeals to the Court of Appeal. This is outrightly unconstitutional.
I propose the question that clause 28 be amended as proposed. I put the question that clause 28 be amended as proposed. Division at the end.
Clauses 29 and 30.
I propose the question that clauses 29 and 30 be part of the bill. I put the question that clauses 29 and 30 be part of the bill. Division at the end.
Clause 31.
I propose the question that clause 31 be part of the bill. Senator Murkomen. Clause 31.
Very sad, Madam Chair. These amendments are coming to an end. I'm a very sad man. I've really enjoyed this thing, but it's coming to an end. Clause 31. This has been one of my best moments this afternoon, because I know in a few days I'll be vindicated. But how are you able to sit there for the whole afternoon? I'm very, very proud of you, Madam Chair. You are very strong. Whatever you look for Kisumu, they should give you. If you look at clause 31 of the bill, it is proposing, Madam Chair, clause 31 of the bill be amended by deleting paragraph B. If you look at B, it is the same story. A political party that nominates a person for an election under this act shall at least 14 days before submitting the party membership list, submit party membership list to the registrar. Again, you do it, you send the list to the registrar, and then the registrar verifies the names contained in the party membership list submitted by a political party under section 1, and where the names are of members of political party, certify the membership. Again, it's straightforward. The good thing with this part of the bill is that it mirrors the other provisions that are debated earlier using the provisions of the Constitution. So the argument is the same. It is assaulting the constitutional responsibility of IBC under Article 88 of the Constitution, and therefore I'm proposing that we delete. And then 31C, again, this new section. First of all, just imagine, Madam Chair, people who have managed parties like Senator Pareno, how do you support this thing? Anyway, I know you will not vote on it, but I'm just saying, how do you support such a provision? Look at it. Just look at it if you are running a party. In fact, if I want to frustrate a political party under this bill, I just wait for them to do their nomination and go around carrying, collecting the book they are using, and then I contest everything they do and say the register has a name of so-and-so who is supposed to be a party, who is a member of another party. In fact, one of the provisions here, which I did not remove, which I did not propose for amendment, is, Madam Chair, it says that it shall be an offense for you to register somebody without their consent. Now there's so many people in ODM register, millions, who are there without their consent. There are millions in Jubilee register. No, I'm serious. Millions in Jubilee register. I don't know about UDA and these new parties. But the old parties I know for sure have so many people who are there against their own will. That is enough ground to contest an election of a particular party. So now you go ahead, having managed a party and gone through what a party does, and you make this proposal that says, a political party intending to submit a party list to the commission should at least 14 days before the submission of the party list to the commission, under 35, submit the party list to registrar for certification. Now you have about 50 political parties. They send first to registrar for certification. Number two, the registrar shall verify that the names appearing on the party list belong to registered members of the political party, blah, 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 all these things. I am saying, for avoidance of doubt, we are erecting blocks and stones against political parties. I know my friend Argura here does not have many problems with this thing. Senator Haji here, this is not an issue. In fact, they are wondering what is all this debate about, because their nominations are done. You know, they are finished. Now they are just waiting to enter the party they choose. But those of us who come from party strongholds, where you have to go through rigorous, especially you, Senator Chilayako, to get ODM certificate in Migori is not a joke, my friend. And therefore, if I want to just mess up with your nominations as a party, I just go to court and say ODM did illegal nominations. Here is the party register they used. Here are the people who are there illegally. Oh, blah, 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 blah. All those procedures you do not fit into. And then an independent candidate becomes the only candidate running. And you find in a region where it was strong in a certain political party, because of the strict provisions you put here and some mundane things and very difficult things that you put in these bills, you will suffer and you will remember, son of Reverend Joanna Kanda.
Senator, I think you are...
Thank you, Madam Chair.
Okay. I propose the question that clause 31 be amended as proposed. I put the question that clause 31 be amended as proposed, division at the end. Senator Were, online. Can we have Senator Were online?
Madam Chairman.
It's Senator Were. You want to say something? Just go ahead. Okay, fine.
Madam Chair, can you hear me?
Madam Chair, I've heard Senator Murkomen talk many times about the Constitution.
I had two amendments.
Just hold on. Senator Were, 1 minute. Just hold on. Senator Chilo.
Two amendments to
Just hold on, Senator Were.
at clause 31.
Can you wait then? I will give you time. I'll give you. Okay, Senator Were, go on.
Be amended in the
On clause 31.
section 38G by deleting subsection 3. Subsection 3 talks about delegates in an indirect party nomination. And that section suggests that a delegate's ID number,
Senator Were, are you hearing me?
contact, and even address be taken to the IBC. That is exposing the delegate to danger, and it
Senator, can they stop?
subject to abuse. So I propose that that be deleted. I have a further amendment on clause 31, which says that the bill. Okay. I've been told to hold on a bit. Let me know when I should continue.
Senator, first of all, move the amendment on 31 first.
Okay. I move that clause 31 of the bill be amended by inserting the following new paragraph immediately after paragraph C. That is B. That in section 43, by deleting the word 6 months, appearing immediately after the words office at least, and substituting therefore the words 4 months. This is in reference to public servants, or what we commonly call civil servants, who are required to resign 6 months to election. And every election cycle, these civil servants have to always go to court to remove this particular article. Why would we have a law that does not seem to serve the people it is intended for? And it is therefore the role of Parliament to amend the law if it is not working for the people it's supposedly meant for. So that is the main premise for my amendment of this clause. Thank you, Madam Speaker. Can I proceed with clause 24?
No, just a minute. I propose the question that clause 31 be amended as proposed. I put the question that clause 31 be amended as proposed, division at the end. Now you can go ahead and propose on the amendment on 24.
Thank you, Madam
Clause 24,
Speaker.
please.
In clause 24 of the bill, I propose that it be amended in the new section 38G by deleting subsection 3. Subsection 3 talks about delegates who are supposed to elect a candidate for a political party in an indirect nomination process. Madam Speaker, that subsection suggests that we should send, or parties should submit, delegates' ID number, delegates' contact, delegates' address, delegates' phone number, and even email address. It proposes that those details of delegates be submitted to the IEBC. Madam Speaker, that is a process that is subject to abuse. That is a process that is dangerous to delegates. They will be bribed, they will be taken to hotels, and it will subvert the essence of democracy that is supposed to be free and fair. It will be very dangerous even to political parties. We'll have rival political parties targeting those delegates and making sure that they vote either for a weak candidate or strong candidate, whatever case may be in their favor. So I propose, Madam Speaker, that we delete that subsection 3. Thank you, Madam Speaker, for indulgence.
I propose the question that clause 24 be amended as proposed. I put the question that clause 24 be amended as proposed, division at the end. Now, Senator Mwaura is meant clause 11. Senator Mwaura.
Thank you, Madam Speaker. Madam Speaker, I'm present. Madam Speaker,
you
can hear me?
Hey.
Madam Speaker. Madam Speaker, you can hear me?
You are not clear. Can you be clearer? Yeah, now go ahead.
I'm here, Madam Speaker. I seek to move an amendment under section 40, clause 11, I beg your pardon, which reads as follows, that clause 11 of the bill be amended by inserting the following new section immediately after the proposed new section 14B. So the new 14C shall read, 14C1, a political party may, notwithstanding section 14A and 14B, and upon deeming a member to have resigned or finding a member to have contravened any provision of the constitution of the political party, and before expelling a member, take disciplinary action measures including A, warning a member, B, reprimanding a member, C, suspending a member, D, removing a member from a leadership position in a legislature, or removing a member from the membership of committees in a legislature. 2, a person who is deemed to have resigned or is expelled from a political party shall not lose their elective seat unless all possibility of appeal or review of the decision has been exhausted. Madam Speaker, Madam Chair, why I'm proposing this amendment is to, number one, provide that political parties do not rush to expel a member out of just the political winds of the moment, because that has been a very clear case, is to actually give avenue by law, not even just by the party constitution, but by law, that there is a procedure which then gives both parties a chance to make amends or even to have a sit down. Number two, is also to guarantee that in the process an expansion is procured by the party, you don't lose your seat as a member until you have gone to the to all the appeal mechanisms. And this is actually to give effect to Article 99, Sabbatical 1 read together with Sabbatical 3, which exactly states that of the Constitution. But now currently, as you know, my case, which is really a very clear prototype, you have a situation where before even a disciplinary committee of the party sits, party officials declare that one is going to be expelled. Indeed, you go through that process, and the outcome is the same. For example, in my case, the Jubilee National Disciplinary Committee recommended, according to the court documents that we later on got, that I should be suspended for 6 months, but that was varied to an expulsion. But that it was only an afterthought when the political party possibly realized that they never followed the constitution. Dear fellow senators, I think this is very, very important because you know the way in which political alliances shift, and you don't know who then would want to use the law to settle political scores. This will actually protect members from losing their seats at any given point in time until the courts pronounce themselves at the Supreme Court. And I agree with Senator Murkomen earlier on, who had actually said there should be 21 days upon gazettement of the notice of expulsion. Because, you know, sometimes you don't even know whether the registrar has accepted the decision of the party, and especially when the registrar is subject to the appointing authority of a political party, which could be the ones that has formed government, as is the case currently. And further, also to really state clearly, some of these things are done in a very shadowy manner, within a very short time before you knew it. Like for me, on the 11th of, I lost the case on 7th of May, but on the 11th, on the 10th of May, there was a purported gazette notice, really, which was issued on 11th and backdated to 7th. So such kind of misbehavior, and especially when you know very well that government pressure can be controlled by the political party in power, can only be cured through this process. So that then, if then you are accused or you have actually been expelled, you can seek redress before any action is taken. And for example, if I had been successfully expelled, that would have actually opened the door for any person who differs with the executive or the
Senator Mwaura, would you want to summarize?
And I think a very good example, Madam Chair,
kindly summarize.
The leader who during the old days, he was a member of parliament in the morning, in the afternoon he was not. It was the same case for me on the 12th of May. It was a very painful process. I had to be in court for over 30 times, and even somebody else was illegally gazetted to replace me. So I think this cures this problem, and it protects everyone from any shenanigans of a political party that is opaque and not transparent. I beg to move.
I propose the question that clause 11 be amended as proposed. I put the question that clause 11 be amended as proposed, division at the end. Senator Ochila Yako, I promised to give you an opportunity to, because we couldn't get you to speak before Senator Were.
Thank you, Madam Chair. Madam Chair, I appreciate the fact that we have all been sitting for long, so I'll not be very detailed. Madam Chair, I just want to ask Senator Murkomen to have this in mind. He has been mentioning this when moving his amendments. If you look at Article 88 of the Constitution, which establishes IBC and also confers upon IBC responsibilities, and you read it against the provisions of Article 92, which is legislation on political parties, there is nothing in Article 88 that gives exclusivity on political parties to IBC. In fact, Article 92 gives Parliament the authority to make legislation and assign those regulatory responsibilities and management responsibilities of political parties to another entity. So perhaps as Senator Murkomen considers what he's been saying, that what we are doing is invading the exclusive mandate of IBC, he should also read the two articles, one against the other, and advise himself. Thank you, Madam Speaker.
Thank you. Senator Pareno, I did not see your intervention for a very long time. Can you make your comment, please, and briefly?
Thank you, Madam Speaker. I kept trying to get your attention because severally Murkomen and Senator Murkomen, Senator Cheruyot, severally have mentioned that Pareno could be quiet here while things are going wrong. But I want to say that with a little, not really so little experience that I've had in running political parties, this bill has come in to cure a lot of gaps that we have had in running primaries for political parties. So it's just curing the mischief that has been there. For example, Madam Speaker, because Senator Murkomen has talked so much about the register and why the registrar should be given powers to verify the membership and verify the register. Madam Speaker, we know that it has been a problem. You get to do your primaries and other parties come to gang up against the most popular candidate just because there is no register to verify who is voting. So I want to say that this has come in to bridge that gap that has been created by the act that we had. In fact, most of the things that are being proposed and the proposal that Senator Murkomen has been putting across are actually things that have been in the original act, and all we are doing is tighten the gap, Madam Speaker. So that is what I wanted to clarify, because at so many times they have said, oh, Pareno is here, how would you allow parties to, you would suffer? We are not going to suffer, we are going to have better management of political parties with this bill.
Thank you, Senator. Next.
The title and clause 1.
I propose the question that the title and clause 1 be part of the bill. I put the question that the title and clause 1 be part of the bill, division at the end. The bell be rung. Can the bell be rung for 5 minutes because you want to move to division, please? 5 minutes. Please add another 3 minutes.
Then from here we are moving to clause, no, the one with amendment, clause 28.
Can the bell be stopped? Honorable Senators, kindly take your seats. Kindly take your seats. Tell us, please come to the dispatch. Can we have the tellers, the two tellers at the dispatch? Senator Shionga and Senator Faria.
Oh, yes, with amendments.
Honorable Senators, we are going to do 3 divisions, one at a time. Honorable Senators, can we have some order? We are doing 3 divisions, one at a time. The first division is the at the closest with amendments. I put the question. I put the question that clause 2, tell us please. Senator Shionga for the ayes? Senator Shionga for the nays, and Senator Cherargei for the ayes.
Yes, put the question, the first one.
Let's have some order, please. I put the question that clause 2, as proposed by Senator Murkomen, clause 9, which is a deletion, clause 11 by Senator Murkomen and Senator Mwaura, clause 20, clause 22 by Senator Murkomen, clause 24 by Senator Murkomen, clause 28, clause 31 by Senator Murkomen and Senator Were be amended as proposed.
Roll call.
Roll call.
Senator Adan Duro Fatuma, Isiolo County.
I vote no.
Senator Ali Abdurai Ibrahim, Wajir County.
I vote no.
Senator Boy Isa Juma, Kwale County.
I vote no.
Senator Cherargei Samson Kiprotich, Nandi County.
On behalf of the people of Nandi, I vote yes.
Senator Cheruiyot Aaron Kipkriu, Kericho County.
After all that noise, he runs away.
Senator Haji Abdur, Garissa County.
Madam Chair, I vote no.
Senator Harigura Godana, Marsabit County.
Madam Chair, I vote no for all the amendments.
Senator Imana Malakai Charles, Turkana County. Senator Kajwang Moses Otieno, Homa Bay County.
Madam Speaker, I vote no.
Senator Kamar Margaret, Uasin Gishu County.
I vote yes, Madam Chair. No. I vote no. I vote no.
Senator Kangata Irungu, Muranga County. Senator Hanir George, Vihiga County.
Madam Chair, Vihiga votes no.
Senator Kibiru Charles, Kirinyaga County. Senator Kihika Susan, Nakuru County.
I vote yes. No.
Senators, kindly keep quiet. Can we need to have some order in the House so that we get the correct votings so that there are no confusions. I think he mentioned the Senator Kihika.
No, Kibiru.
No, Kibiru was outside when you mentioned first.
Madam Speaker, you are quite right.
Yes, Kibiru was outside, then you mentioned Kihika. So can we have Kihika? Just go through that again.
Senator Kihika Susan, Nakuru County.
Repeat those ones who have not voted.
Senator Kibiru Charles, Kirinyaga County.
I vote no.
Senator Kimani Wamatangi, Kiambu County.
Madam Speaker, I vote no.
Senator Kindiki Kithure, Tharaka Nithi County. Senator Kirinyaga Ephraim Mwangi Maina, Nyeri County.
Coming on.
Madam Speaker, I vote no.
Senator Langat Christopher, Bometi County. Senator Lelewe Tumbesi, Samburu County. Senator Linturi.
No, Lelewe is in the House.
Madam Chair, I vote yes.
Senator Linturi Mithika, Meru County. Senator Loitip Annual, Lamu County. Senator Masayo Stewart, Kilifi County.
I vote no. Madam Chair, I vote no.
Senator Mahmoud Mohamed Malim, Mandera County. Senator Malala Cleophas, Kakamega County. Senator Mbito Michael, Trans Nzoia County.
Madam Chair, Trans Nzoia vote no.
Senator Mbogo George Ochiro Ayako, Migori County.
Madam Chair, I vote no.
Senator Mogeni Eric Okongo, Nyamira County.
Madam Speaker, I vote no.
Senator Moi Gideon, Baringo County.
I vote no.
Senator Mpaye Philip Salau, Kajiado County. Senator Murkomen Kipchumba, Elgeyo Marakwet County.
Madam Chair, I vote a big yes.
Senator Mudhama Agnes, Machakos County.
Madam Chair, I vote no.
Senator Mutula Kilonzo Jr., Makwiny County. Senator Mwangi Paul Githiomi, Nyandarua County.
Madam Chair, I vote no. And another no.
Senator Mwaruma Jones Mwasushe, Taita Taveta County.
Madam Chair, on behalf of Taita Taveta, I vote no.
Senator Munhaji Mohamed Faki, Mombasa County.
Madam Chair, I vote no.
Senator Nderitu John Kinywa, Laikipia County.
Madam Speaker, I vote yes.
Senator Ndwiga Peter Njeru, Embu County.
Madam Speaker, I vote no.
Senator Olekina Ledama, Narok County.
Madam Chair, on behalf of Narok County, I vote no.
Senator Ongeri Samson, Kisii County.
Chair, Kisii County votes no.
Senator Orengo James, Siaya County.
Madam Chair, I vote no.
Senator Outa Frederick Otieno, Kisumu County.
It's not working. Oh, okay. Madam Chair, I vote no.
Senator Pogisho Samuel, West Pokot County. Senator Sakaja Johnson, Nairobi City County.
Madam Chair, on behalf of the great people of Nairobi, I vote no.
Senator Wako Amos, Busia County.
Madam Chair, Busia County votes no.
Senator Wambua Enoch, Kitui County. Senator Wario Golich Juma, Tana River County. Senator Wetangula Moses, Bungoma County. Do I repeat? Do I repeat again? Senator Cheruiyot Aaron, Kericho County. Senator Imana Marakai Charles, Turkana County. Senator Kangata Irungu, Murang'a County. Senator Kihika Susan, Nakuru County. Senator Kindiki Kithure, Tharaka Nithi County. Senator Langat Christopher, Bomet County. Senator Linturi Mithinka, Meru County. Senator Loitiptip Anwar, Lam County. Senator Mahmoud Mohamed Maalim, Mandera County. Senator Malala Kilofas, Kakamega County. Senator Mpaye Philip, Kajiado County. Senator Mutula Kilonzo Jr., Makwiny County. Senator Bogisho Samuel, West Pokot County.
Madam Chair, I vote yes. I'm sorry, Madam, sorry. Council, Madam Chair, I'm trying to vote yes. Madam Chair, I vote no.
Senator Wambua Enoch, Kitui County. Senator Wario Golich Juma, Tana River County. Senator Wetangula Moses, Bungoma County.
Honorable Senators, we are moving to the second division. We will announce the results at the end. I put the question for the second division. Those are for independent amendments. I put the question that Clause 2 by Senator Cherargei, Clause 24 by Senator Cherargei and Senator Were be amended as proposed. Register.
Senator Adan Duro Fatuma, Isiolo County.
I vote no.
Senator Ali Abdurai Ibrahim, Wajir County. Senator Boy Isa Juma, Kwale County.
I vote no.
Senator Cherargei Samson, Nandi County.
On behalf of the people of Nandi, I vote yes.
Senator Cheruiyot Aaron, Kericho County. Senator Haji Abdul, Garissa County.
Yes.
Madam Chair, I vote no.
Senator Harigura Godana, Marsabit County.
Madam Chair, I vote no.
Senator Imana Charles Marakai, Turkana County. Senator Kajwang Moses Otieno, Homa Bay County.
Madam Chair, I vote no.
Senator Kamar Margaret, Uasin Gishu County.
Madam Chair, I vote no.
Senator Kangata Irungu, Murang'a County. Senator Hanir George, Vihiga County.
Senator, we are not hearing you. Senator Haniri.
Senator Kibiru Charles, Kirinyaga County.
I vote no.
Senator Kihika Susan, Nakuru County. Senator Kimani Wamatangi, Kiambu County.
Madam Speaker, I vote no.
Senator Kindiki Kithure, Tharaka Nithi County. Senator Kirinyaga Ephraim Mwangi Maina, Nyeri County. Senator Langat Christopher, Bomet County. Senator Lelewel Tumbesi, Samburu County.
Madam Chair, I vote yes.
Senator Linturi Mithika, Meru County. Senator Loitiptip Anual, Lam County. Senator Masayo Stewart, Kilifi County.
I vote no.
Senator Mahmoud Mohamed Maalim, Mandera County. Senator Malala Kilofas, Kakamega County. Senator Mbito Michael, Trans Nzoia County. Senator Mbogo George Ochiro Ayako, Migori County.
Madam Chair, I vote no.
Senator Mogeni Eric Okongo, Nyamira County.
Madam Speaker, I vote no.
Senator Moi Gideon, Baringo County.
I vote no.
Senator Mpaye Philip, Kajiado County. Senator Murkomen Kipchumba, Erigeyo Marakwet County.
Vote, Madam Chair, I vote a big yes.
Senator Mudhama Agnes Kavindu, Machakos County.
Madam Chair, I vote no.
Senator Mutula Kilonzo Jr., Makwiny County. Senator Mwangi Paul Githiomi, Nyandarua County.
Madam Chair, I vote no.
Senator Mwaruma Jones Mwasushe, Taita Taveta County.
Madam Chair, I vote no.
Senator Mwinyihaji Mohamed Faki, Mombasa County.
Madam Chair, I vote no.
Senator Nderitu John Kinywa, Laikipia County.
Madam Speaker, I vote yes.
Senator Ndwiga Peter Njeru, Embu County.
Madam Speaker, I vote no.
Senator Olekina Ledama, Narok County.
Madam Chair, Narok County votes no.
Senator Ongeri Samson, Kisii County.
Madam Chair, Kisii votes no.
Senator Orengo James, Siaya County.
Madam Chair, I vote no.
Senator Outa Frederick Otieno, Kisumu County.
Madam Chair, I vote no.
Senator Bogisho Samuel, West Pokot County.
Madam Chair, I vote no.
Senator Sakaja Johnson, Nairobi City County.
I vote no.
Senator Wako Amos, Busia County.
Busia County votes no.
Senator Wambua Enoch, Kitui County. Senator Wario Gorich Juma, Tana River County. Senator Wetangura Moses, Bungoma County. I'm repeating now. Senator Ali Abdurai Ibrahim, Wajir County.
I vote no.
Senator Cheriot Aaron, Kericho County. Senator Imana Malakai Charles, Turkana County. Senator Kangata Irungu, Murang'a County. Senator Hanir George, Vihiga County.
Senator Niri. Yeah, there is.
Vihiga votes no, Madam Chair, to the amendments.
That's fine.
Senator Kihika Susan, Nakuru County. Senator Kindiki Kithure, Tarakaniti County. Senator Kirinyaga Ephraim Mwangi Maina, Nyeri County. Senator Langat Christopher, Bomet County. Senator Linturi Mithika, Meru County. Senator Loitiptip Anual, Lamu County. Senator Mahmoud Mohamed Maalim, Mandera County. Senator Marala Kilofas, Kakamega County. Senator Mbito Michael, Trans Nzoia County.
No.
Senator Mbito Michael, Trans Nzoia County.
Madam Chair, I vote no.
Senator Mpayei Philip, Kajiado County. Senator Mutula Kilonzo Jr., Makwiny County. Senator Wambua Enoch, Kitui County. Senator Wario Gorich Juma, Tana River County. Senator Wetangura Moses, Bungoma County. So results for the two. Yes, for the two. For the two. You can keep this.
Honorable Senators, we'd like to give you results for the first two divisions. The first division, ayes 4, nays 28. The nays have it. On the second division, ayes 4, nays 27. The nays have it. Honorable Senators, all the amendments have been defeated. Now we want to take a vote or a division on the bill.
So put the question. Put the question.
Yeah, so that they can go with or without amendment.
No, put the question.
I put the question. I put the question that clauses 2 to 31, the title and clause 1 be part of the bill. Register.
Senator Adan Duro Fatuma, Isiolo County.
Yes.
I vote yes.
Senator Ali Abdullahi Ibrahim, Wajir County.
I vote yes.
Senator Boy Isa Juma, Kware County.
I vote yes.
Senator Cherarke Samson, Nandi County.
Madam Chair, on behalf of the great people of County of Nandi, I vote a big no.
Senator Cheruyot Aaron, Kericho County.
Whether it is big,
Put on this mic. Put
the
on
vote
this mic.
doesn't change. It doesn't have a sign.
Senator Haji Abdur, Garissa County. Garissa, wewe wacha kutiki.
Madam Chair, I vote yes.
Senator Harigura Godana, Marsabit County.
Madam Chair, I vote yes.
Senator Imana Malakai Charles, Turkana County.
Honorable Senators, can we have some order?
Senator Kajwang Moses Otieno, Homa Bay County. Senator Kamar Margaret.
Just a minute, just give the mic. There you are.
Madam Chair, I vote yes.
Senator Kamar Margaret was in Gishu County.
Madam Chair, I vote yes.
Senator Kangata Irungu, Murang'a County. Senator Haniri George, Vihiga County.
Madam Chair, Vihiga votes yes.
Senator Kibiru Charles, Kirinyaga County.
Vote yes.
Senator Kihika Susan, Nakuru County. Senator Kimani wa Matangi, Kiambu County.
Madam Speaker, I vote yes.
Senator Kindiki Kithure, Tharaka Nithi County. Senator Kirinyaga Ephraim Mwangi Maina, Nyeri County.
We can't hear you. I think you are on mute. Unmute, please. Not yet.
Hello?
Yes, now it's okay.
Can you hear me?
Yes.
I vote yes.
Senator Langat Christopher, Bomet County. Senator Lelewel Tumbesi, Samburu County.
Madam Chair, I vote no.
Senator Linturi Mithika, Meru County. Senator Loitip Annual, Lamu County. Senator Mazayo Stewart, Kilifi County.
I vote yes.
Senator Mahmoud Mohamed Maalim, Mandera County. Senator Malala Cleophas, Kakamega County. Senator Mbito Michael, Trans Nzoia County.
I vote yes.
Senator Mbogo George Ochiro Ayako, Migori County.
On behalf of Migori, I vote yes.
Senator Mugeni Eric Okongo, Nyamira County.
Nyamira votes yes.
Senator Moi Gideon, Baringo County.
I vote yes.
Senator Mpayei Philip, Kajiado County. Senator Murkomen Kipchumba, Elgeyo Marakwet County.
Madam Chair, I vote yes. I vote no.
To be clear. Yes.
Madam Chair,
so,
I vote no.
Ask for order for the House.
Huh? Please, Senator Murkomen, vote.
Madam Chair, I vote no.
Senator Mudhama Agnes Kavindu, Machakos County.
Machakos votes yes.
Senator Mutula Kilonzo Jr., Makwiny County. Senator Mwangi Paul Githiomi, Nyandarua County.
Madam Chair, I vote yes.
Senator Mwaruma Jones Mwashushe, Taita Taveta County.
Madam Chair, I vote yes.
Senator Munyihaji Mohamed Faki, Mombasa County.
Madam Chair, I vote yes.
Senator Nderitu John Kinywa, Laikipia County.
Madam Speaker, I vote no.
Senator Ndwiga Peter Njeru, Embu County.
Madam Speaker, I vote yes.
Senator Olekina Ledama, Narok County.
Madam Speaker, Narok County votes yes.
Reporting forms. Senator Ongeri Samson, Kisii County.
Kisii County votes yes.
Senator Orengo James, Siaya County.
Madam Chair, I vote yes.
Honorable Senators, can we have some order? Some order, please.
Senator Outa Frederick Otieno, Kisumu County.
Madam Chair, Kisumu vote yes.
Senator Pogisho Samuel, West Pokot County.
West Pokot votes yes.
Honorable Senators, please don't leave. We still have a final vote.
Senator Sakaja Johnson, Nairobi City County.
Madam Chair, I vote yes.
Senator Wako Amos, Busia County.
Madam Chair, I vote yes.
Senator Wambua Enoch, Kitui County. Senator Wario Golich Juma, Tana River County. Senator Wetangula Moses, Bungoma County. Senator Cheruiyot Aaron, Kericho County. Senator Imana Malakai Charles, Turkana County. Senator Kang'ata Irungu, Murang'a County. Senator Kihika Susan, Nakuru County. Senator Kindiki Kithure, Tharaka Nithi County. Senator Langat Christopher, Bomet County. Senator Linturi Mithika, Meru County. Senator Loitip Anual, Lam County. Senator Mahmoud Mohamed Maalim, Mandera County. Yes. Senator Malala Cleophas, Kakamega County. Senator Mpayei Philip, Kajiado County. Senator Mutula Kilonzo Jr., Makueni County. Senator Wambua Enoch, Kitui County. Senator Wario Wolich Juma, Tana River County. Senator Wetangula Moses, Bungoma County.
Honorable Senators, results for the third division. Ayes 28, nays 4. The ayes have it. Mover. Senator Majority Leader.
Madam Honorable Chairpersons, I beg to move that the committee do report to the Senate its consideration of the Political Parties Amendment Bill, National Assembly Bills number 56 of 2021, and its approval thereof without amendment.
I put the question, which is that the committee do report to the House its considerations of the Political Parties Amendment Bills, National Assembly Bills number 56 of 2021, and its approval thereof without amendments. May as many as are of the opinion say aye. Aye. And those of the contrary opinion say nay. Nay. The ayes have it.
Madam Speaker. Mr. Speaker.
Okay, let me call the chairperson to report.
Honorable Speaker, I beg to report that the Committee of the Whole has considered the Political Parties Amendment Bill, National Assembly Bills number 56 of 2021, and its approval thereof without amendments.
I call the mover.
Honorable Speaker, I beg to report that the Committee of the Whole, Honorable Speaker, I beg to move that the House do agree with the committee in the said report. I ask Honorable Orengo to second.
Mr. Speaker, sir, I beg to second.
I will propose the question, which is that the House do agree with the committee in the said report. I put the question, which is that the House do agree with the committee in the said report. As a matter of that opinion, say aye. Aye. As a matter of account of you, say nay. Nay. The ayes have it. The mover.
Honorable Speaker, I beg to move that the Political Parties Amendment Bill, National Assembly Bills number 56 of 2021, be now read a third time. I move and ask Honorable Orengo to second. Thank you.
Mr. Speaker, sir, my pleasure to second.
I will propose the question, which is that the Political Parties Amendment Bill, National Assembly Bill number 56 of 2021, be now read a third time. I will put the question, which is that the Political Parties Amendment Bill, National Assembly Bill number 56 of 2021, be now read a third time. As a matter of that opinion, say aye. Sorry. Aye. Okay, the bell be rung for 1 minute. Okay, I'll put the question, which is that the Political Parties Amendment Bill, National Assembly Bills number 56 of 2021, be now read a third time. I now direct that the names be called out. The tellers. Cherargei, you are the teller.
Senator Adan Duro Fatuma, Isiolo County.
I vote yes.
Senator Ali Abdurai Ibrahim, Wajir County.
I vote yes.
Senator Boy Isa Juma, Kwale County.
I vote yes.
Senator Cherari K. Samson, Nandi County.
Mr. Speaker, on behalf of the great people of Nandi County who are rejecting this unconstitutionality and illegality, I vote a big no.
Senator Cheruiyot Aaron, Kericho County. Senator Haji Abdul Mohammed, Garissa County.
Mr. Speaker, sir, I vote yes.
Senator Harigura Godana, Marsabit County.
Mr. Speaker, I vote yes.
Senator Imana Malakai Charles, Turkana County. Senator Kajwang Moses Otieno, Homa Bay County.
Mr. Speaker, the instructions I have from the great county of Homa Bay is to vote yes.
Senator Kamar Margaret was in Gishu County.
Mr. Speaker, I vote yes.
Senator Kangata Irungu, Murang'a County. Senator Haniri George, Vihiga County.
Mr. Speaker, sir, Vihiga votes yes.
Senator Kibiru Charles, Kirinyaga County.
The great people of Kirinyaga votes yes.
Senator Kihika Susan, Nakuru County. Senator Kimani Wamatangi, Kiambu County.
Mr. Speaker, I vote yes.
Senator Kindiki Kithure, Tharaka-Nithi County. Senator Kirinyaga Ephraim Mwangi Maina, Nyeri County.
Senator Maina, vote. Unmute. Unmute and vote. Unmute. We can't hear you. Eh? Okay. Is yes, okay. Yeah. Eh?
Yes, will come.
Okay. They will come to him, okay. Okay. Okay.
Will come later. Senator Langat Christopher, Bomet County. Senator Lelewel Tumbesi, Samburu County. Senator Linthuri Mithika, Meru County. Senator Loitip Anwal, Lamu County. Senator Mazayo Stewart, Kilifi County.
Mr. Speaker, Kilifi votes yes.
Senator Mahmoud Mohamed Maalim, Mandera County. Senator Malala Cleophas, Kakamega County. Senator Mbito Michael, Trans Nzoia County.
Mr. Speaker, Trans Nzoia votes yes.
Senator Mbogo George Ochiro Ayako, Migori County.
Mr. Speaker, Migori votes yes.
Senator Mugeni Eric Okongo, Nyamira County.
Mr. Speaker, Nyamira votes Yes.
Senator Moi Gideon, Baringo County.
Baringo votes yes.
Senator Mupayei Philip Salau, Kajiado County. Senator Murkomen Kipchumba, Elgeyo Marakwet County.
Mr. Speaker, I vote no.
Senator Mudhama Agnes Kavindu, Machakos County.
Mr. Speaker, Machakos votes yes.
Senator Mutula Kilonzo Jr., Makwiny County. Senator Mwangi Paul Githiomi, Nyandarua County.
Mr. Speaker, sir, I vote yes.
Senator Mwaruma Jones Mwasushe, Taita Taveta County.
Mr. Speaker, on behalf of the great people of Taita Taveta, I vote yes.
Senator Mwinyi Mohamed Faki, Mombasa County.
Mr. Speaker, sir, I vote yes.
Senator Nderitu John Kinywa, Laikipia County.
Mr. Speaker, I vote no.
Senator Ndwiga Peter Njeru, Embu County.
Mr. Speaker, I vote yes.
Senator Olekina Ledama, Narok County.
Mr. Speaker, on behalf of the great people of Narok County, I vote yes.
Senator Ongeri Samson, Kisii County.
Speaker, Kisii County votes yes.
Senator Orengo James, Siaya County.
Mr. Speaker, sir, Siaya votes yes.
Senator Outa Frederick Otieno, Kisumu County.
Mr. Speaker, Kisumu vote yes.
Senator Pogisho Samuel, West Pokot County.
Mr. Speaker, I vote yes.
Senator Sakaja Johnson, Nairobi City County.
Mr. Speaker, on behalf of the people of Nairobi and on behalf of the Kenya Kwanza Uchumi Kwanza Alliance, because we also want a coalition, we vote yes.
Senator Wako Amos, Busia County.
We also want an alliance.
Mr. Speaker, on behalf of Busia County, I vote yes.
Senator Wambua Enoch, Kitui County. Senator Wario Golich Juma, Tana River County. Senator Wetangura Moses, Bungoma County. Senator Cheruyot Aaron, Kericho County. Senator Imana Malakai Charles, Turkana County. Senator Kangata Irungu, Moranga County. Senator Kihika Susan, Nakuru County. No, Ephraim hasn't voted. He hasn't voted. Senator Kindiki Kithure, Tharaka Nithi County. Senator Kirinyaga Ephraim Mwangi Maina, Nyeri County. Senator Kirinyaga Ephraim Mwangi Maina, Nyeri County. Senator Langat Christopher, Bometi County. Senator Lelewel Tumbesi, Samburu County. Senator Linturi Mithinka, Meru County. Senator Loitiptip Anwal, Lamu County. Senator Mahmoud Mohamed Maalim, Mandera County. Senator Marala Kilofas, Kakamega County. Senator Mpayei Philip, Kajiado County. Senator Mutula Kilonzo Jr., Makwiny County.
Maina is there?
Yes.
Senator
yes,
Wambua Enoch, Kitui County. Senator Wario Golich Juma, Tana River County. Senator Wetangula Moses, Bungoma County. Senator Kirinyaga Ephraim Mwangi Maina, Nyeri County.
I vote yes. Can you hear me?
We have heard you. Honorable Senators, these are the results of the division. The ayes 28, nays 3, abstentions 0. The ayes have it.
A bill for an act of parliament to amend the Political Parties Act and for connected purposes.
Okay, Honorable Senators, I wish to defer the other business that had been listed on the order paper, and therefore it's now 9:01 p.m. Time to adjourn the House. The Senate, therefore, stands adjourned until Thursday, 27th January 2022 at 10 a.m.